Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020, 7:44 p.m. How, does the FBI find people, and people misspelled P-E-O-O-P-L-E?
I object.
Did the defendant find out how the FBI finds people in this case? Oh, she found out.
Welcome back to the Court of Public Opinion. I am the Recovery Addict. Somebody said they had loop back echo. Are you guys still hearing that? No? I didn't see it. Big welcome to Greeners. First in chat today, Greeners. Hold on one second. I'm rebooting my computer. Don't look at my password. I got the password wrong anyway. I got the password right. Second time. All right, Greeners. I have to properly shame you, Greeners, by putting your name on the screen for all to see. First in chat, yet again, my comedic timing is thrown off if you're 20 minutes late. Okay, I'm sorry. Look, what I was doing right up until we went live, Mrs. R.A. and I were literally sitting together, having some good couple time, watching YouTube of how to build a bathroom, because we did the math, and I think we're actually regressing in the progress in the bathroom remodel. We have lost ground, so to speak. It's going to take longer now to create the bathroom than the whole project should have taken at the current rate I'm going. So we were watching videos of how to create a wall, because we have to build a wall, and I'm not a wall building sort of guy. That's not my forte. Arguably, I'm not even an on-time sort of guy. So we were watching some YouTube videos together of other people building the walls. We were having a discussion about whether or not I needed some additional equipment to be able to build the wall. I'm thinking, no, not an alarm clock, Selena K. I'm thinking that the equipment that's needed is a auto laser level. I think with that piece of equipment, building will be so much faster, because I can just set it down, turn it on, and it'll make a nice little laser X on the wall, and I can just make sure everything is square and straight and in the right position. Just hire someone, no headaches. Hi, Barb, tell me you don't live in North Carolina without telling me you don't live in North Carolina. No, I don't mean to be rude, Barb. Please don't be offended by that. You can't. Either you can't afford them, or they don't want to work on the house. It's an old house, and they come in, you get a bid for somebody. We ask for somebody to give us a bid for cleaning out a drain. They charge us $6,000 to clean out a drain just because it's old. It's old. Nobody wants to work on it. And the people that will do it charge, more than the house is worth to get the work done. It's crazy. So anyway, so I have to go to YouTube University and learn skid loader. Maybe it might be time for the skid steer. But now that I have properly watched videos of people building a wall, I know what to do, and tomorrow I should be able to get a wall built. That's the goal. All right, sell house to guy who called. This is Northwest. I already told him no. Oh man, yes, maybe I need to do that. Let me quit this. Quit Stream Deck. Quit that. Quit Lumia Stream. There we go. Okay, now we're almost there. I do apologize. I did say we're going to try to come back and watch the rest of that. We're not going to have time. They're coming back live here in just a moment, and we want to be live as we follow this. I will share with you a link for Court TV's coverage of the, Todd's original testimony if you want to watch the rest of it. Otherwise, we're going to have to jump to this, which is not a replay. Let me fix that. It's going to be like so. All right. There we go. So we'll be back. We'll be back there in just a moment. Sell house to guy who called. Barb, that's cool. No, I wish we have run into this problem. It's an issue because we live in an area that's hit hard by hurricanes. This is the actual reason. Our area specifically doesn't get a lot of damage, but within an hour of us, there's significant damage every time a hurricane comes through. And because of that, there are people with a lot more money than me who are seeking for laborers to come and do the work and repair their beach house, repair their vacation home, and they have more money to offer, and the jobs are pay a lot more than mine does, and so there's no reason for a handyman. Construction company to come in and work on a little job right here where there's not a lot of money, and there's risk with just going bad because it's an old building and all sorts of problems. You inherit all the buildings of every builder before you who worked on it, and they stick to the lucrative jobs. And every time you try to get a bid here, they just put pie in the sky numbers, and they know you won't go with that. So there's a little Eastern North Carolina honesty for you. Will you take us on a road trip to look for a house? Right now, it's just online. It's just on Zillow. And I've learned from Daniel at Arms Family Homestead, the YouTube channel. They did take their community live with them. Not live, but they shared a video of them going looking for a small home to purchase as an Airbnb, a rental. It would be their beach house, their lake house, and when they're not using it, they'd rent it as an Airbnb. And they found one, and they're like, we're really excited about this one. Like the next day, as soon as the video went live, one of their viewers put money down on the house and bought it out from under them. So I can't do that. I can't risk that, because if Mrs. RA does find the house that she definitely wants, I can't let you guys steal it. So anyway, we will, small jobs always cost more. They're ridiculous. Anyway, fun times. I actually love where I live. It's amazing. But if we ever do get a new home, I'm sure a studio is going to be the number one consideration for me. But my consideration only comes in after Mrs. RA's considerations are all met or exceeded. Okay, let's see if this is working now. Not working. Okay, we're waiting for audio or video. We all promised to sign an NDA. Let's see. The funny thing, Jules, I'm not sure if it was like an avid fan who just wanted to be like, hey, I'll be next door neighbors, or I'll buy the same one. This will be funny. I don't know, but Daniel's wife, I'm trying to remember her name. I can't remember it off the top of my head. She loved that one. It was like the perfect house, and it just got snatched out from under them. And there had been no offers on it for a long time. It just sat there for a while. DJ, yes, thank you. DJ, says Janet. I love that channel. I watch that channel every single day. I watch his updates. Mostly, I think they're the cutest couple on YouTube. Obviously, Mrs. Ari is the cutest wife on YouTube, but they're the cutest couple on YouTube. I'm not sure what that's saying about me, but Deanie says, not complaining, but I never got a welcome from Ari. Deanie Mullis Diver, welcome. Congratulations, brand new follower. We know, brand new member. Might have been here a little bit longer, but I see that blue courthouse by your name, which means you're in your not your probationary period, but you're still being initiated into the group, fully welcomed in and made one of us. So, welcome, welcome. I'm sorry you didn't get a welcome. It's good to see you though. All right, I'll pass that message on to Greeners. He knows what to do there. Still waiting for court. Hey, Mrs. R.A., I'm sure would say the same about you. She is wonderful. She's very kind. Too kind, maybe. Gailey May, member for 22 months. 22 says 2 more months and I get a new Kohler. Yes, you would get, or Kohler. How do you guys say it again? I say Kohler. You'll get that magenta or the pink courthouse, which looks fantastic, I might add. Fun fact. YouTube has given me the opportunity to add one more color to the membership level, so that the pink one might not be the final one. We could add one more. I don't know which one to go with. What do we end on? A purple? Let me go look again. Jamie, member for 18 months. Thank you very much. If I didn't call it the 18 months, congratulations. Yay, look, a whole year and a half. Love it here. That's wonderful. Tease T gifted 5 memberships. Tease T, thank you very much. A Dutch staying in touch. Congratulations. Carolyn Johnson, Christy Silo, Teresa Beckner, Panda Beery, I think it's Barry. All wonderful, wonderful recipients there. Pink isn't the final. There are 2 colors after, and purple is the end. All right, but after purple, I have one more slot. Okay, that's looks like we're coming back to court here.
Recording in progress.
We're on YouTube now. I'd like Zoom.
All right,
YouTube.
good afternoon. We'll go back on the record. Mr. Firehelm, are you able to hear me? And you are muted currently.
So we can't hear if you are.
Okay, you are very quiet. Is it possible for you to turn up your volume?
That's not how it works, Judge.
I have it as high as I can get it.
All right, I'll see if we can turn up ours, maybe.
Prepare your ears for what's about to come.
All right, would you try it again for me, please?
Yes, Your Honor.
All right, that's much better. Perfect. Okay, counsel, I think we're picking back up with Mr. Firehelm's testimony. Is that correct? Yes. All right, Mr. Firehelm, I will just swear you in again quickly since it's a new day. If you'd raise your hand. Do you swear the testimony you're about to give will be true and correct?
Yes, Your Honor.
All right, and I know that the camera angle is not the greatest, but hopefully you can see counsel well enough. Counsel, if you need to move or adjust yourself in the courtroom, please feel free to do so.
Phrasing. Danny Austin just gifted 5 memberships.
Thanks for coming back today, Mr. Firehelm. We appreciate it. I wanted to pick back up discussing the discovery that you were tendered before Mr. Mullis's trial.
Where's Jake?
Do you recall if that discovery included audio and video files?
Did we lose him?
I believe it did. I'm not 100% sure.
Mr. Firehelm, for some reason we lost your video. I'm not sure. There you're back. Okay.
Do you recall specifically audio and video of an interview with your client, Todd Mullis, November 16th, 2018?
If that was the interview by DCI, I believe he was at the Law Enforcement Center. Yes, I do.
Do you recall reviewing one of Tristan Mullis done by DCI November 16th, 2018?
I think so, yes.
And are you familiar with investigative techniques such as the Reed technique?
Yes, I am.
And is it your understanding that the Reed technique is designed to obtain a confession from a suspect?
I believe so, yes. That's my reading of it.
Sinbad, it might
Did
have
you
bad word in it.
consider or investigate whether the DCI agents were utilizing such techniques on Todd Mullis and Tristan Mullis?
I didn't match up their technique with the Reed technique, although I've seen DCI use it pretty consistently.
And Your Honor, I'm going to object on this point solely for the fact that evidence already within the record has testimony that's been uncontroverted essentially at this point. As Special Agent Turbot testified, he did not use the Reed technique, if I remember correctly.
Overruled.
Mr. Fireholm, I think my question really is that you had some education or knowledge about interrogation techniques at the time you represented Mr. Mullis?
That's correct.
And did you take any actions or conduct any investigation to have those interviews reviewed by somebody more knowledgeable than you?
No.
Could you have consulted an expert regarding coercive interviewing techniques?
Yes, yeah, they're expert for everything.
So true. Is that a pallet
Did you
flag
consider investigating or locating any witnesses that could testify to Todd's good character?
I didn't. Bob had a lot more contact with local people and family than I did.
Great, thank you.
Miss Violet, congratulations. Happy birthday.
I know yesterday we talked a little bit about the 911 call that the state played during trial. Do you remember that discussion?
Yes.
Do you recall if you listened to it before trial?
He said he didn't.
Yes, I'm certain I did.
And
choo-choo.
And then do you recall ever playing it for Mr. Mullis?
I do not recall doing that, no.
During Mr. Mullis's cross-examination, did you consider objecting to the mischaracterization by the prosecutor that Todd was alone at the time of those purported statements?
No, I don't think so.
Did you investigate the timing of the purported statements in order to contradict that state's argument?
Are you referring to the cross-examination questions or that claim by the prosecutor that he was whispering something to her? Is that what you're referring to?
Yes.
That wasn't an issue. There was no warning about that at all until it happened.
And so you weren't able to look into the timing of those statements?
No.
If you had had notice of those statements, could you have done some investigation to learn whether another deputy or another person was on scene at that time?
Well, I think it was pretty clear there was another deputy on scene. There was back and forth between Todd and a deputy before that allegedly happened.
Okay, and you didn't point that out during trial?
Again, it came up right there at the end in almost the last question she asked him or presented it to him. So no, I didn't.
Thank you. I want to move on now. Do you remember the name of a witness, Tom Krogman?
Yes, I think so, yeah.
Do you recall there being a DCI interview that included audio?
I don't. I'm not saying there wasn't, I just don't recall it right now.
You've got mail. What you looking at?
Do you recall, in your review of the discovery, DCI agents telling witnesses that the medical examiner's opinion was gospel?
I don't remember that being said.
Did you consider calling Mr. Krogman as a witness at trial regarding his observations during the emergency medical services on the side of the road or his observations at the hospital?
I don't think so, no.
Do you recall an email between you and Mr. Sabers about whether you should call Mr. Krogman?
Not specifically, no.
Every time the ghost train howls, which also sounds like the wind blowing, we add to the train counter. We're also counting every time the train blows its whistle when it drives by outside.
I didn't make it. Hey, Josh.
Whisper loud. Whisper louder. This, you might as well just talk at full volume.
Just a moment, Your Honor. I think I'd like to refresh the witness's recollection, but between the Zoom and the sharing, I need just a moment here.
Okay, just let us know when you're ready, please.
Of all the Zoom testimony we've heard, this is not the hardest to hear. I think the worst we've ever had was probably during a pre-trial hearing for Sarah Boone with the feedback that was just terrible. Didn't we have like one from a cruise ship on the Maya trial? Zoomed in from a cruise in Greece or something? Yeah, I'm not going to complain here, Allie, for sure.
Your Honor, at this time, we'd like to share our screen to show an email to Mr. Firehome, but we're not seeking to admit it. It's just to refresh his recollection.
Okay, is this something that has been marked as an exhibit that we can refer to for the record, or?
It is not, Your Honor.
All right. Counsel, are you aware of what's being displayed to the witness?
Yes, Your Honor.
All right, go ahead.
For the record, Your Honor, I think our next number is 977. Mr. Firehome, can you see that?
Yes.
If you would just review it and let us know when we can take it down.
Apparently,
Okay.
So did Mr. Sabers and you discuss calling Mr. Krogman as a witness for Todd?
That was September 13th, I think. There was such a flurry of emails going back and forth then. I don't specifically recall that one, but I do now remember Bob bringing that up, and I don't know if we talked on the phone or just traded the emails about it.
And that would have been right before the trial started. Is that your recollection?
Yeah, just a few days before.
You've got mail. Oh, she has a stopwatch counter. See the red lights by the flag?
I want to move on a little bit here and ask, are you familiar with the field of biomechanical engineering?
No.
Do you
know what it is, but
I'm sorry.
I'm sorry I interrupted you. I know what it is, but I'm certainly not an expert or that knowledgeable in it.
Did you consider consulting an expert in biomechanical engineering to investigate whether Amy could have sustained her injuries in a fall?
No.
Did you consider or investigate the principles of force that could be generated from a fall versus a strike or a swing of the rake?
I did not.
I want to show you Exhibit 233, which we looked at yesterday. It's a letter from Mr. Mullis to you. I understand, I think it's undated.
Yeah, Katrina, this is continuing that testimony. This is the same attorney, just now he's on Zoom instead of in person. So we're just finding out a little bit more.
I can see it, yes.
Okay, thank you. And if we can scroll, I think it starts on page 3 and 4. They're very small for me.
Oh, look at the drawing. Oh, my goodness.
Did you understand Mr. Mullis to be asking questions here about investigating a theory that Amy died from an accidental fall?
Hello, Tristan.
Certainly that's what he's referencing there in the photos or the drawings that he made. But I don't know when. Without a date.
Would you agree that this would be a letter that Mr. Mullis sent you before trial?
Oh, yeah, yes.
And do you recall Mr. Mullis asking you to investigate how the far right tines did not come out of Amy's body?
I don't remember that specific question, no.
All right. If we could go to the first page, bottom paragraph. Could you review that for me?
There's a real train.
Okay.
Would you agree that Mr. Mullis is asking you to verify the possibility of it being an accident?
That's what it says, yes.
And then on the second line, never truly, was totally out of the far right wound?
That's what it says.
Okay. Okay. So would it be fair to say that you weren't considering, the principles of physics or Newton's law of motion when you reviewed the autopsy report?
Excuse me, can you say that again?
Sure. Is it fair to say, based on your prior testimony, that you weren't considering the laws of physics or like Newton's law of motion when you reviewed Dr. Cruz's autopsy report?
No, I wasn't considering that type of technical analysis.
And because we're lawyers, that's why we would hire an expert?
Yes.
If you had evidence before Mr. Mullis's trial that a swing of the corn rake could not have generated enough force, would you have presented that to the jury?
Well, I guess you start out, if we had that, if evidence or witnesses are helpful to a case, of course you present it.
And if you had talked to an expert and that expert explained to you that the laws of physics made it impossible for the corn rake to have been swung into Ms. Mullis, would you have presented that to the jury?
Based on that hypothetical, yes.
If you had evidence that it was impossible for the corn rake to have been pushed or kicked into Ms. Mullis, would you have also presented that?
Same answer.
Did you present any evidence that Mrs. Mullis' death was the result of an accidental fall?
No.
And when Todd took the stand to testify, did you ask him any questions that would support that Ms. Mullis' death was the result of an accidental fall?
There may have been some questions about what he told law enforcement and medical people right after this happened, but I don't recall. I don't think there would be any other place in his testimony or I would have questioned about that.
Did you present any testimony or evidence about the prescription medications that Amy Mullis was taking at the time of her death?
I don't think so.
Did you consider or present any testimony or evidence that Amy Mullis was anemic at the time she died?
I don't think so. Todd may have testified about her being weak and dizzy when she was out in the barn helping get things cleaned up, but I don't remember if there was any specific evidence about any medical reports or evidence about her being anemic.
Do you recall in your opening statement telling the jury that Ms. Mullis was deliberately and viciously murdered?
I don't know if I used those words, but yes, that's what I was telling the jury.
Okay. I want to circle back to the text message evidence that was presented at trial. Do you remember there being text messages as a topic with quite a few witnesses?
Yes, I think so.
Do you recall there being witnesses who testified that Amy was unhappy or scared of Todd?
Yes.
Did you obtain copies of the full text messages or cell phone records for Amy and Todd Mullis?
I don't think we had 100% of the records? No, if that's what you're asking.
If we could show the witness Exhibit 307, the first 18 pages only.
The first 18 pages? Read fast.
Mr. Fireholm, do you know if you've seen this document before?
The best answer I can give is I don't think so.
If there are text messages between Todd and Amy that contradicted what witnesses said at trial, would you have used those?
I'm not sure what you mean by contradict.
Would you characterize the state's evidence as attempting to, paint a picture of discord between Todd and Amy or tension?
Your Honor, I am going to object on the grounds of 5403 and relevance. This evidence is not admissible, and so it's immaterial, but it's also a report that was generated by Mr. Castle and wasn't a part of the underlying record at the time Mr. Firehelm even represented them.
I guess, Ms. Nichols-Cook, did you want to respond to that?
Well, Your Honor, it's already admitted. I am not asking this witness to admit it. It's the whole point, right? He didn't have this information because he didn't request it, and he could have used it to impeach the witnesses at trial that talked about messages with Amy that the state relied on.
Right. Kelly, can you read me back what the question was?
She wasn't listening.
Would you characterize the state's evidence as attempting to, paint a picture of discord between Todd and Amy, or tension?
Yeah. The objection's overruled.
Mr. Firehelm, do you need the question again?
Please.
Did you understand the state's evidence at trial, or would you characterize it to be attempting to show that Todd and Amy were unhappy, or that there was tension in their marriage and in their home?
Yeah, I think that's fair.
So we're going to scroll down here. What page? Page 14.
Yep.
And I think I can direct you to line 233. And then 234 after it.
You need to scroll a little bit. I can't see 233. Okay.
Can you tell me what the dates are for line 233 and 234?
October 14th, 2018.
And this would have been shortly before Ms. Mullis passed away?
About a month.
And would you agree that the content of these messages contradict the state's narrative?
Yeah, those two do, yes.
Okay, we can take that one down.
That was at 10:14. Love you too. Back and forth.
Mr. Firehelm, did you take any steps to impeach or discredit the witnesses who testified at trial regarding Todd and Amy's relationship?
Well, I guess the record would speak for itself. I think we cross-examined them, but I don't recall specifically.
I'm sorry. Did you take any steps to determine if Amy Mullis had a Facebook account?
I don't remember.
Could it have been helpful to you to present evidence from Amy that her and Todd were happy?
Yeah, I suppose it could have been interesting or relevant to the jury, inconsistent with what was going on, but
So, Mr. Firehelm, do you recall reviewing phone records from Terry Stainer?
I might have, but I don't think so.
Do you recall Terry Stainer's testimony at trial?
Not in any way I could talk about it today.
If I represented to you that the transcripts indicate that Terry Stainer was testifying about Amy being upset or scared of Todd, or that she testified about Amy saying, "Look for me in the timber," would you agree with that?
Yes, I think so.
If we can show the witness 372. Do you know if you've ever seen this before, Mr. Firehelm?
The best I could do is I don't think so.
And can you tell what it is?
It looks like phone records, and at the top it says David Stainer.
If these phone records would have impeached Terry Stainer, would you have used them at trial?
Sure.
If they would have discredited her about Amy coming to her house crying in October 15th, 2018, would you have impeached her with proof that Amy didn't?
anytime you can discredit a witness, you try. I don't know how this would do that, but yes.
Okay, we can take that one down. Mr. Firehelm, do you remember a witness by the name of Corey Volker?
I don't recall that name.
You don't recall any investigation into Mr. Volker's relationship with Amy?
I'm not connecting that name with her, no.
Former lawyer definitely isn't falling on his sword to try to give his clients a new trial. His former clients.
Do you recall having in discovery text messages between Amy and Corey Volker?
I'm not recognizing that name.
Would you be surprised to learn that Mr. Volker knew about Amy's affair with Jerry Frazier?
Again, without picturing him or linking him somehow, I'm at a loss here.
We could show the witness 268. So, Mr. Firehelm, can you look at this and tell me what it is? To the best of your, I guess, ability to identify it.
It's SMS text messages. It says Corey Volker.
And have you ever seen this before?
I don't think so.
Okay. Okay, we can take that one down. Do you remember there being witness testimony about Amy screaming and getting into a fight or being upset with Todd? Oh, looks like Mr. Firehelm is frozen.
Mr. Firehelm, are you able to hear us?
Yes, I can.
Okay. Looks like your video is frozen.
I'm not a cat. I'm ready to proceed, Your Honor. I am here.
I don't recall a screaming match between Amy and Todd, no.
Do you recall any text messages about Amy screamed?
I'm not recalling it today, no.
And did you do any investigation to determine the facts surrounding the text messages the state presented at trial?
No, I don't recall at this time.
Mr. Firehelm, you might want to turn your camera off and turn it back on. It looks like you're still frozen here, but we can hear you.
Right now, I've lost that bar at the bottom where I can turn things on and off. All I have is that exhibit in front of me right now.
Oh, we've taken the exhibit down, so I am not sure what advice to give you. Oh.
You see me now?
Yep.
Okay.
We're back. We talked a little bit yesterday about Todd asking you to have the accident theory investigated. Do you recall that?
Yes.
And I wanted to clarify if it was your testimony that Todd Mullis was just shotgunning, and if you could explain what that characterization means.
Well, Todd would write these long letters. Well, not all of them long, but there was a lot of it. And there would be ideas or questions and so forth. And like I said, since I couldn't email him back, we would either when I went to see him at the jail or when we talked on the phone, we would address those things. And that's how I kind of interpret Todd told me and Bob, you know, I'm just sitting here, I'm thinking, I'm putting these things out there. That's kind of what I meant.
Okay, that helps.
I didn't mean what he was doing was inappropriate. It's just that's kind of the methodology that went on between the three of us.
Do you recall answering Todd about whether the two tines ever came out of the right two wounds?
I don't remember that type of specificity. I don't think we did, no.
Would you say that Todd consistently asked you about evidence that Amy's death was the result of an accident?
Earlier on, yes, and maybe continuing for a while, but I don't think that was a big issue as we came down the stretch towards the trial.
Do you recall testifying in your deposition that Todd never stopped asking you to investigate whether it was an accident?
I don't recall that specific question, no.
If we can...
Now we're going to refresh his recollection with
We
transcripts.
will show you your deposition, Mr. Firehelm, just a moment here.
I have it here if you want to give me a page.
Yes, if you could turn to page 23 and look at line 5.
$23?
Yes, page 23, line 5.
Okay, I see it.
And so in your deposition, you testified, no, Todd never stopped asking about experts in an accident theory?
That was my answer, that's correct.
Okay. I want to touch on communication with Mr. Mullis briefly. I believe you said you testified that Todd would call you from the jail before trial?
Yeah, I remember there were phone calls, yes.
Did you have concerns about the confidentiality of those phone calls?
I don't remember if the jail staff assured us that they would be confidential or not. I think they did. But I'll answer your question. No, I didn't have a concern.
So do you recall telling Todd that you couldn't say a whole lot on the calls when he would call you?
I don't remember that.
Now we've had audio and everything cut out here. Give it a second. We'll take this brief moment to update the title.
No.
Do you know if you scheduled legal calls at either the Buchanan or Dubuque County jails?
I really, it would just be a wild guess. At Dubuque, we would have had to have done it in the evening, and I think
it was the opening
I
statement.
was there. But I'm pretty sure it was more than once. I know the night before the trial started, I went there on a Sunday night. But I think there were more than that.
I want to pivot now to your opening statement at this trial. Did you discuss that with your co-counsel, Mr. Sabers?
This is main counsel from this trial, not co-counsel.
I think Mr. Sabers was there the night before the trial started. And whether or not we talked about the opening statement, I don't remember.
Do you remember testifying in your deposition that you didn't give him a copy or a draft of your opening?
That would be accurate. I don't remember specifically in the deposition, but that would be true.
That night before trial began and you met with Mr. Mullis in the Dubuque County Jail, did you tell him what the substance of your opening statement was going to be?
I don't remember.
Okay, I want to pivot again. I'm sorry. I feel like I just keep jumping. You testified yesterday that you visited the Mullis farm, and I believe that you looked into the shed and kind of in the farmyard.
We went to the shed where this took place, and I don't think we went into the other buildings, but Lynn and Mike pointed out, I'm pretty sure Mike was there, what the other buildings were, and like there's the 2 hog barns, there's the machine shed, and so forth. And then I think it was just Lynn and I went in the house and sat and talked.
Do you recall taking any steps to learn what Amy was doing before her death in the hog barn?
What she was doing in the hog barn?
Right, before she went to the shed?
Just what just what Todd and Tristan testified to. And that's what Todd had told me in our conversations.
So, do you recall there being injuries to Amy's right hand?
I don't recall specifically, no.
Do you recall doing any investigation to determine if they could have been caused by cleaning the light fixtures in the hog barn that morning?
There was no investigation as to that, and I don't remember Todd or Tristan saying that that had happened. Todd said he was concerned about her balance and being, she was trying to do too much after this medical procedure.
So, Mr. Firehelm, I should have shown this to you yesterday, so I apologize, but this is demonstrative 275. I don't know for sure which camera
One up on the ceiling.
Try not to cough. Do you know if you've ever seen this before?
Try not to cough.
We're going to try another camera.
The state's helping him out.
Do you know if you ever saw this before?
I don't think so.
Did you ever consider if Amy was cleaning these and putting her hand in there that it could have created injuries on her hand?
Objection, speculation.
Sustained.
Did you ever consider if the hog barn light fixtures could have caused an injury to Amy Mullis's hand?
No.
Thank you. Thank you, Tom.
Thank you, Tom. It's funny, they help
Do you recall
show
doing
it
any
when they object.
investigation into farming accidents as a theory of defense?
No investigation into that, no.
Do you recall examining the corn rake that officers seized from the farm?
This is important.
During the trial, yes.
During?
But not before. Is that what you're telling me?
Yes.
He didn't. Whoa.
So did you see the blood on the handle of the corn rake?
Not before the trial.
Did you take any investigative steps to determine how the blood would have gotten there or whose blood it was?
No.
Do you recall Todd asking you in letters to look at the rake and the physical evidence?
I think he did, yes.
Did you ever look at Amy Mullis's clothing from November 10th, specifically the coat, the sweatshirt, and the long sleeve shirt that she was wearing when she was injured?
No.
Did you take any investigation into the holes in the clothing in relation to Amy's injuries on her body?
Well, when you say investigation, I mean, there were photographs in the reports that were made part of the discovery, but any specific investigation or having some independent person look at them and so forth, no.
Did you take any steps to reconcile Dr. Cruz's opinion that the rake would have been swung 2 to 3 times, but there were only 4 holes in the coat?
No, I don't think so.
And Mr. Firehelm, are you looking at your deposition? I see you're looking down.
I have it right here in front of me, yes.
Okay.
Any objection to that?
Any objection to that? We've updated the counter label to show that it's a ghost and train counter.
Do Do you recall looking into the security camera system at the Mullis farm?
It was either Mike or Lynn showed it, the one camera over in the machine shed, I think, that was not functioning.
Do you recall testimony from state witnesses that the security cameras were not working November 10th, 2018?
I don't know if they testified that all security cameras were, but the only one I remember there being concern or testimony about was that one. Because I think it would have been directed towards the shed where this happened.
Do you recall Deputy Himsath testifying that the cameras had been turned off?
I think he did, yes.
If you had evidence that Todd was not on the farm when that happened, would you have presented it to impeach Deputy Himsath?
You have to say yes to that.
I'm not recalling Himsath's exact testimony about whether or not he thought Todd turned them off or when they got turned off. So I don't know how I would have used it.
Do you recall an inference that in committing murder, Todd would have turned the cameras off that the state was trying to make?
Well, yeah, I think they were trying to create whatever inference they could.
And if you could have rebutted that inference, would you have?
Sure.
Did you do any investigation to determine whether Amy Mullis or her boyfriend Jerry Frazier could have turned off their surveillance cameras to hide their affair?
No.
It's an interesting reason
And you
why.
didn't consult any expert about the surveillance footage?
No.
And do you remember doing any investigation as to whether the camera lost signal versus things were deleted?
No.
Okay. I think yesterday we talked a little bit about hearsay objections and your motion in limine. Do you remember that?
Yes.
Did you know that by failing to make an objection during trial that you were waiving that issue for appeal?
Yes.
You knew that you were waiving the
Did
issue
you
for
have any
appeal?
discussions with Todd about waiving that appellate issue?
No, I don't think we did.
If the transcripts reflect that you didn't make any hearsay objections during the testimony of Terry Stainer, would you agree with that?
I think I would, yes.
Would the same be true then for Patricia Christofferson
I think so.
and Carrie Callanan?
Yes.
Okay. Do you remember discussions with Mr. Sabers about seeking a change of venue for the trial?
Yes.
Who asked for that?
Do you... Let me start over. Was venue changed from Delaware County?
Yes.
And where did it go?
Dubuque County.
Did you consider asking for an additional change of venue from Dubuque County?
I don't know if we considered filing another request. I know I think Bob actually maybe was the one that made the comment that we had gone from the frying pan into the fire as far as publicity and so forth.
Did you know if both Delaware County and Dubuque County share a media market?
Yeah, well, I know that from growing up, the Telegraph Herald comes out of Dubuque, the daily paper, and the Waterloo TV station cover, I think, both counties.
Do you recall expressing frustration to your co-counsel that a jury in Dubuque was not going to be any more neutral than one in Delaware?
I don't know if I said it or Bob said it or we both did, but that's certainly.
Did you have any considerations about whether a jury in Dubuque would have a fair cross-section representation of jurors?
I don't know if that was a comment maybe made by the trial judge or by somebody in the room, so to speak, that it was just a more populated county than Delaware.
Selena, are you okay?
Do you remember considering or researching whether farmers are excused from jury duty in September due to harvest?
I didn't research it, but I've certainly had trials where farm chores and field work came up as an issue about whether or not a person stayed on the jury or not.
Do you remember any investigation or research into what kinds of jurors you thought could be fair and impartial?
I just relied on my experience.
Do you recall investigating whether Todd was planting crops or harvesting at the time of any of the Google searches that the state attributed to him?
Selena, if there's anything we can do, let me know. I have connections in that part of the world.
Certainly Todd
911's better than anything I could do.
Told us that, which I think was confirmed by Mike or Lynn or both.
Did you do any investigation or seek any documents that would have confirmed Todd was operating the planter in April and May of 2018 during these questionable Google searches?
No, I don't think so.
Are you familiar with the Farm Acre Book and farm insurance?
Familiar with what?
A Farm Acre Book and the concept of farm insurance? Crop insurance, I'm sorry.
No, I'm not.
If you could have produced evidence that Todd did not have access to the iPad or the internet on the dates of those searches, would you have presented that at trial?
Yeah, sure.
Do you recall telling the court that you had a family issue come up during this trial?
Yes.
And would that have been distracting to you?
It was concerning, yes.
I want to talk a little bit about Jerry Frazier and your references to him or your plan with regards to evidence about Jerry Frazier. Do you remember who he is?
Yes.
Do you recall in your deposition explaining that you were going to point to him as a possible perpetrator? That was part of your plan?
Yeah, I think so.
Did you have any evidence that supported that Jerry Frazier had come onto the Mullis farm November 10th and attacked Amy?
I don't recall that.
Do you recall deposing Jerry Frazier?
Yes.
Do you recall whether he had an alibi for the time that she was injured?
I believe he did.
Did you have any other evidence that you were going to present at trial?
So Selena's told me 911 is on the way.
Supported
She's got
Jerry
help coming.
Frazier being the perpetrator?
She's been texting me directly.
Nothing other than his relationship with Amy.
Did you have any other evidence to present that someone else was on the farm that day?
No.
Do you recall your closing argument?
Not really. Not any specifics.
Do you recall arguing that it was a murder mystery?
I might have said that. I don't know.
Would you defer to the transcript?
Yes.
Have you ever challenged chain of custody or contamination of evidence in a criminal case?
Yes.
In your representation of Mr. Mullis, did you investigate how the corn rake was handled by law enforcement?
I don't recall doing that, no.
Do you recall considering whether additional forensic testing of the rake could be helpful to you?
I don't recall considering that, no.
Can I have just a moment, Your Honor? I think I might be done.
You can.
So Selena had a fall. She's texted me. She texted me a picture even. She's got 911 on the way. I think it was a fall on the stairs, which are scary. Looks like help is on the way. We're just waiting for good news that everything's okay. Hopefully it's just checking out. I'm not aware of any specific injuries, but thoughts and prayers for Selena right now would be great. Thank you, Selena. Please.
I'm going to step away and lock my front door so we don't get interrupted.
Okay, thank you.
Who's outside? She got a. I'm not going to share the picture. I'll leave that for her. She sent me a picture. All safe now?
Mr. Firehelm, my last question. Do you remember there ever being a time that Todd Mullis agreed with you that Amy's death was a homicide?
I don't think he ever said those words, no.
Nothing further from the applicant, Your Honor.
Cross-examination,
Cross.
Mr. Duden?
Yes, Your Honor, but I wonder if now's maybe a good time to take an opportunity for a bathroom break and to reset. If possible, we could take like a 10, 15-minute recess if that's okay.
We certainly can. Let's go ahead and take about 15 minutes. We'll plan on picking up at 2:25. Mr. Firehelm, I will just leave the Zoom on so you can stay logged in, and everything should hopefully still be operational when we come back. Court's in recess until then.
All right, so they go on quick break, and let's see. Got to go to the little lawyer's room. I have a sign that says little lawyer's room somewhere. Oh, it's right here. Look. Little lawyer's room. We'll be right back. We're going to stay right here. I'm hoping for a word from Selena. She's, I don't know if there's a specific injury. Obviously, I think with any fall, concern of concussion is always there, but she was able to text me a picture that she took. She took a selfie after the fall so I can see, and she's been texting. She says 911's on the way. It sounds like she had a fall on the stairs, and help is either en route or currently taking her to somewhere where she can get checked out. So she probably can't text us right now. She hasn't responded since she let me know that 911 was en route. Thoughts and prayers for her would be great. She's out in the Utah area. One of the ones I wanted to meet with while I was out there. We missed a lot of people out there. All right. Yeah, she's a friend here. In other news, I know there's in the Karen Reed trial. Well, we have just a slight break here. There's a little development where apparently the defense has now asked for a longer delay. The hearing that was going to address the big, long document we read yesterday, they've asked for a delay in that because, you'll never guess why, because the prosecution is still turning over more video. You can't make this up. And the chain of custody files for some of the other videos. So more video, more evidence just now being after we've filed for a dismissal. They're like, oh wait, that reminds me. One more thing. They pull a Steve Jobs there. There's one more thing. Yeah. Oops. So we'll see. There might be a little delay there. Oh no. Hang on. Might be more significant. Selena's still texting me, so I don't want to share all of her details from her a terrible fall. But possible serious leg injury. So keep her in mind. That's no fun. They're going to bring out the ambulance. So, All right. Yes, she's chatting with me right now. I might see if I need to call her off the air or something. I want to make sure help is there before we rest assured that everything's fine. I missed a ghost sound. There we go. I just added it. We're up to 33 now. Okay. Ambulance is here. And she's going to call me. Okay. All right. All right. Thank you. Thank you very much. Alexis, welcome to the jury. Brand new member in the jury. Thank you. Thank you very much. A little bit of a break here in the trial. We have Mr. I can't remember his name. Todd Mullis' attorney speaking here has just finished direct examination, and will now enter cross. And this is a really going to be an interesting exchange. Okay, we've got a few minutes before it starts, because we have the prosecutors of the previous case questioning the defense of the previous case, trying to show what a good job he did when he lost. Okay, so they're what can they do? They can go dive into all the things that they, that all the evidence that he looked at and said, yeah, it's pretty obvious. This is the best way forward. Is that what you did? And he probably is going to say yes. So he's probably going to say, I did, what any lawyer would do. I looked at the evidence. I put the pieces together, and the best thing I could do was, because it was, in my eyes, murder. The best, and I thought that any jury would see that immediately. So the best thing to do was get out in front of that and say, this was murder, but it wasn't our guy. That's where they probably are going to go. But it's interesting to see the prosecution trying to build up the other side after they've just, they've fought against him for so long. So, all right. Yes, I can look at the pin. Jake Feuerhelm, Mr. Feuerhelm. Is the guy. OG Sean White says, remind me never to hire this lawyer. Sean, I will remind you. Never hired him. No, I don't. Let me say this about that. It is very easy the day after the Super Bowl to pick apart every play, every decision, every formation, every on-field, change of plans, at the line of scrimmage, decision made by the quarterback to do something else. Why didn't you hand it off? Why did you pull the handoff back? Why did you decide to throw? Why, when you had a clear lane to run? It's really easy to second guess that. They call it armchair quarterback, where we get to sit back and, especially with the benefit of hindsight, be able to second guess all this. The Todd Mullis' team here has to prove that it's more than just, I would have done something different, or another lawyer might have gone a different way. They need to prove that Mr. Feuerhelm didn't do what every other lawyer or any other good lawyer who has sworn an oath to, or has been sworn in, would do in defense of a client. That's the bar they have to reach. So, this community is simply the best, says Lynn in South Carolina. Continued prayers for Selena K. She's got the ambulances there now, so that's what I was worried about. I wanted help to be there. Now she says she's going to call me as well, so probably once she's checked out and stabilized. And thanks for alerting me. I did not see her initial message, so thank you in chat for letting me know. As soon as I went to text her directly, because we have exchanged texts previously on the burner phone, I was going to reach out to her, and she had just barely texted me. So that was wonderful. Deidre, I'm seeing a strong argument for that. I just don't know how high the hurdle is to prove that he was ineffective as counsel. I think there's some revisionist history happening to fit their current narrative. Tumwater Troy, I would definitely see that Todd's team has assembled evidence that wasn't assembled previously, and in light of that new evidence, it definitely makes it look worse that it wasn't assembled previously. They're trying to admit that those reports, the call logs from somebody who said something happened that didn't. They didn't have the reports, or he never sought them out. Now, look, with hindsight, comparing that, looking at, it's like, oh, you should have done that. Is that an armchair quarterback decision? Or is that just a trial strategy saying, well, we've got to focus on the things that we can and argue the points where we can, and it's not waste our time where we're not actually going to go. So, very windy in Wisconsin. We're up to 33 counters on the ghost and train counter. Most of those are ghost counters, which is just the wind. Yeah, ghosts aren't, well, I said ghosts aren't real, but I've seen one. I'll have to tell you the story one time. Ghosts are quite real. So, we'll save that for, maybe I need to, I might have to go on Trial TV Live with the Squeegee of Justice and talk about my ghost story. I can be a chat ambassador. Campfire ghost stories. I do not like telling ghost stories at night. No, I don't sleep well. One time, tell us the ghost story. It involves me confessing to a crime, and I'm not sure. I'm not sure if I'll ever be allowed back in the country where this occurred. If I do, so I've got to be careful here. And there are other people. There are other participants who I would be outing. I'll have to check with them and see if they're okay with me sharing the story. Go with Danny on doing an unexplained stream. See, I don't have so much. I probably couldn't fill an episode myself with the one story I've had. Well, I guess I have had some stories in the past here in this house, but I think that really was just the wind. I've never been scared in this house of any ghost. But is this the goose story? No, not the goose story. This is the ghost story. I can tell you, I've been attacked by a guy with a pew-pew before. That was pretty scary. But this ranks right up there with that. I don't know. Does UK have a statute of limitations for things like trespassing and criminal mischief and things like that? Let me know. We're waiting for a little bit. We've got a break in court, just waiting for everything to waiting for the defense in this case, which is the prosecution, to get ready for the cross-examination of Mr. Furhelm. Windy in Arkansas with multiple grass and woods fires. Ooh. The windy fires are crazy. February is the fire month for burning. A lot of farms burn in February because it's dry. It's generally cold. Usually you can control the fire pretty well, but let's see. I should set goals and tell stories. Like the Runkle goals. He does goals for hot sauce, right? I don't know. No, you guys would hit it. That's the problem. Then I'd have to tell the story. Lady Frontier, member for a month, says, I've lurked here in England since the Johnny Depp trial, and thank you for my free membership. It's much appreciated. Lady Frontier, welcome. Don't be a lurker. Feel free to jump in and chat whenever you want. It's wonderful to have you here. Thanks for lurking, though. I'd rather you lurk than not be here at all. Let's see. Is criminal mischief spreading months of old defrosted meat all over the Kelly May? No, that was this. That was yesterday. No, it was worse than that. Let's see. I have a YouTube link if anyone's interested. To Kiki, what are you sharing? You've got a channel. Oh, this week we moved into our new build. My son started talking to Michael, and the creepy things never stopped. Oh, my goodness. Crazy. SJ, welcome to the gallery. Looks like a bit of a Mercedes fan there. Or I don't know, the peace symbol. I don't know which one it is. I think that's Mercedes. I should know. I used to own a Mercedes. When I bought my Mercedes, I bought it from a lady who was very sad to see it go, but she didn't need it anymore. And I bought my car the way I've bought every car I've ever owned in my life, which is used. I've never purchased a new car from a dealership. Ever. I've been there to purchase one car, but it was my grandma. My grandma, I went with her to make sure she was getting a good deal, and she showed up, and the dealer was like, let's talk about financing. How much is your amount? And she's like, I want to know what the final total is. How much is the total cost of the car? And dealerships don't like doing that. And they finally gave her the number, and she's like, and who do I write the check out to? So she wrote the check and bought the car. That's the only time. She was amazing. Let's see. Kiki has a haunted house. Blackbird says, I can help. Did you break into Buckingham Palace like the other two blokes? I never broke it into Buckingham Palace. I threw a Frisbee into Prince Charles's backyard, one of his houses. He's got a house, and we were chucking Frisbees in the park, and the wind just caught it, and it sailed and went into the backyard. And, of course, now we have to go around the front to where the policemen are and ask to go get our Frisbee. And they're like, no, we can't get it right now because there should be a guest that may be arriving within an hour, and no one's allowed to be viewed from a window from inside the house. If the guest comes early, we can't have anyone that's actually seen in the backyard. I'm like, their rules are so strict. We lost the Frisbee, never got it back. Let's see. He's King Charles now. Maybe I should ask him for the Frisbee. Now that he's king, do you have a spare Frisbee that showed up in your yard a few years back? England knows. Maybe it's a wash. With my previous crimes, which I was not ever charged with in the country, and the fact that they are now in possession of a Frisbee, which legally belongs to me, maybe we can just call it a wash and call it even. SJ says, thanks for this channel. I listen while I'm working from home. Yes, I love cars. So yes, Mercedes symbol. I love cars. That's awesome. I had a Mercedes. I was telling you the story before we got sidetracked. I had a Mercedes. I bought it from a lady who didn't want to get rid of it, but she did sell it, and we talked her down. As we negotiated. And at the end, she was okay with the number. It was less than she wanted, and it was probably more than I wanted to pay. So I guess we both lost. But when I bought the car, she told me its name was Mercy. And cars have names, right? Yeah, every car's had a name. Every car I've ever owned has had a name. The only problem with that was when I bought the car, it was clear to me that my car was a boy, not a girl. And she had given the car a boy's name. But
for instance, as well as sex abuse and things like that as well, yes?
What?
Correct.
So you have a wide array of experience for high-level felonies and trying those cases. Is that fair?
Yes.
So turning your attention to this case specifically, it's fair to say, I think at this point, you would agree that you represented Todd Mullis in this case, right?
Correct.
When did you begin representing Mr.
That was
Mullis?
right when they came back.
Probably in March 2019, I think.
If I told you that I believe you appeared in the case around March 8th of 2019, is that right?
That sounds right.
And so you appeared shortly after the criminal complaint alleging that he had committed murder in the first degree was filed, right?
Correct.
As you mentioned on direct examination yesterday, I believe you said that you were referred to this case in order to assist Mr. Sabers. Is that fair?
Yes.
Why did Mr. Sabers need assistance in your what was your understanding?
That he did not have jury trial experience at this level of offense.
And so it's fair to say that your experience would be an aid to both Mr. Mullis and Mr. Sabers in trying the case. Is that right?
Yes.
But you did not outright assume the case. You first met with Mr. Mullis' family. Is that fair?
Yes.
That included his sister and brother, I believe, right?
Yes.
And at that time, you talked about the case, right?
Yes.
You also viewed and inspected the property where the murder occurred, right?
Correct.
Is it safe to say that after you drove from I believe your office is based in Des Moines, to Delaware County, that you spent a sufficient or extended period of time discussing the case before taking on any representative role?
Yes.
Did you also speak with Mr. Sabers before assuming the role of counsel in this case?
Yes.
And of course, did you also speak at length with Mr. Mullis?
Yes.
So ultimately, you appeared in the case, but by that point, you'd spoken to multiple people about the facts and circumstances surrounding Amy Mullis' death and Mr. Mullis' charges, right?
Yes.
At all times during your representation, taking it from a big approach or kind of a macro approach before we go to a micro level, you maintained that Mr. Mullis was innocent and did not murder his wife, didn't you?
That's correct.
So at no point in time did you encourage Mr. Mullis to plead guilty, is that fair?
Yes, that's very fair.
At no point did you encourage him to plead to a lesser offense level or level of murder or manslaughter, for instance?
No, sir.
So at all periods of time, I believe, is it safe to say that you believed Mr. Mullis was innocent?
That's correct.
And that's what you held out to the jury over the course of this trial in this case, correct?
That is correct.
So in your investigative steps, as we kind of work our way up towards the trial, again, you interviewed Mr. Mullis' family, yes?
Yes.
And you regularly kept in contact, in fact, with Mr. Mullis' siblings, who were assisting in providing information and conveying information between you, Mr. Sabers, and Mr. Mullis, who was very active in his case's defense, right?
That would be correct.
You reviewed letters?
Yes.
Took phone calls, is that right?
Yes.
Not just from Mr. Mullis, but also from his siblings or family?
Yes.
And in this period of time of about 6 months, it was not just at the beginning that you took these steps, but you followed that all the way through to trial as well, correct?
Yes.
Now, directing your attention to what has previously been marked and admitted as State's Exhibit F in this case, I believe Mr. Bakke is going to put it on the screen for you, if that helps as well.
I have it in front of me.
Perfect. Well, we'll jump right in then. Do you see the email correspondence marked as Exhibit F on your screen as well?
Yes.
Now, would you agree that this is an April 6th, 2019 email from you to your co-counsel, in this case, Mr. Sabers?
Correct.
In directing your attention specifically to what is the first paragraph, let me know if I read this correctly. After again reviewing the medical examiner's report and the photos we do have, I'm almost certain that her death was not a result of accidentally falling on the fork. The number of puncture wounds, the fact that she had several layers of clothing on, the abrasions on her chin/jaw, abrasions on her hands that I will bet will be described as defensive wounds, all lead me to conclude it was a homicide. Did I read that correctly?
You did.
So, less than a month after you appeared in this case and the trial information was filed, this email would suggest that you believe that this was a murder, in fact. Is that fair?
Yes.
And you conveyed that to your co-counsel, right?
I did.
But this wasn't this wasn't the last time that you conveyed to Mr. Mullis or even anyone interested in the case from Mr. Mullis' side, including Mr. Sabers, that you believe this was a homicide, correct?
That is correct.
Is it safe to say that you conveyed that you believe this was a murder with some regularity?
Yes.
To your knowledge, and based upon the notes, do you believe that Mr. Mullis was not supportive of proceeding with that avenue of defense at trial? Put another way, did you have any indication Mr. Mullis was not comfortable with you conceding this was a murder, but that it wasn't him?
I believe he conceded that.
That you were empowered or permitted to go to trial and argue that this was a murder case?
Objection misstates the prior testimony today.
Overruled. The witness can answer.
Could you ask that again, please?
Is it possible to read it back? I apologize.
He doesn't remember what he asked.
That you were empowered or permitted to go to trial and argue that this was a murder case.
Could you hear that, Mr. Firearm?
No.
Oh, so I believe the question was, so you were, in your mind, empowered or permitted to concede at trial that this was, in fact, a murder, right?
Correct.
To your recollection, do you have any knowledge or recollection of Mr. Mullis telling you that you needed to correct your opening statement during questioning or the examination of witnesses?
No.
To your knowledge or recollection, do you believe that Mr. Mullis ever told you not to again say that they believe this was a murder in its closing?
No.
And do you recall that Mr. Mullis himself agreed that this was a murder on cross-examination at trial?
I believe he did.
So is it safe to say that it was undisputed that this was a murder and not an accident during the trial proceeding?
No.
I'm going to object and ask, the question is vague.
It was disputed.
Undisputed
by Todd.
by who? Maybe would help.
Mr. Duden, did you wish to clarify your question?
Sure. So is it your understanding that you, your co-counsel, and Mr. Mullis agreed at the time of trial and throughout that this was a murder case?
I'm going to continue to renew my objection. I don't think this witness can testify as to what Mr. Mullis agreed or what Mr. Sabers thought.
Overruled.
I don't recall either of them disputing or arguing with me about that approach.
And to be fair, as you said earlier, Mr. Sabers in your opinion, lacked the experience in order to be able to try this case, so you became lead counsel, right?
Correct.
Mr. Sabers did not examine any witnesses at trial, right?
He did not.
He didn't do an opening statement.
No.
Nor did he do a closing argument, did he?
No.
So at all points during the trial proceeding, you were representing Mr. Mullis.
Yes.
Now looking back at State's Exhibit F specifically, I'd like to direct your attention to what is paragraph 2, where you say, quote, I expect we would need to have our expert take a look at the state's examiner's work, but I'd be surprised if he disagrees. Our money may be better spent on getting a good private investigator involved, close quote. Did I read that correctly?
Yes, you did.
So even early on in your representation, you were considering hiring medical experts, weren't you?
Yes.
And you were considering hiring private investigators, right?
Correct.
And you were going to investigate this case with the help of experts if it was necessary, weren't you?
That's correct.
But is it fair to say that during the course of your investigation, in your professional opinion with 45 years worth of experience now, that you didn't believe those experts were needed?
That was my conclusion.
Looking to the course of your investigation, you did, however, look at all of the law enforcement reports in this case, didn't you?
Everything that was provided, yes.
You reviewed transcripts of witness statements, right?
Yes.
You received and reviewed audio recordings or video footage when it became available to you, yes?
Correct. Correct.
And you conducted depositions, right?
Yes.
Before those depositions came to be, though, you also looked at this case from the perspective of electronic evidence, right?
Yes.
You actually reviewed Cellbrite phone data, or Cellbrite phone dump, for lack of a better term, that was provided to you by DCI and by the Delaware County Sheriff's Office, yes?
I believe so.
That information included a review of things like the iPad in this case, right?
Yes, it did.
As well as phone records when it was necessary or relevant, yes?
Yes.
And again, you reviewed all of that information.
Yes.
Looking to your depositions here, I believe you conducted around 16 depositions of potential state witnesses before trial, right? Around that number?
That sounds about right.
You conducted depositions of lead investigator, for instance, Special Agent Turbot?
Yes.
And if you recall, when you deposed Special Agent Turbot, you did so with the view that you were also going to ask about potential other suspects in the case, right?
I think so, yes.
And is it fair to say that during that deposition, you also asked about a potential affair between Amy Mullis and sheriff's deputies from the Delaware County Sheriff's Office?
I think we got into that, yes.
And so now that individual's name, I believe you know to be Rowley as a last name, as well as potentially others, right?
I think that's right, yes.
And do you have any reason to doubt that in Special Agent Turbot's notes, he referred to Rowley as Raleigh with an A instead of an O? Does that sound or ring a bell to you?
Yeah, it kind of does ring a bell, yes.
And in fact, you asked about those circumstances in that report when you deposed him, fair?
Yes.
Drawing your attention to what's previously been marked as State's Exhibit G, do you have that exhibit in front of you, Mr. Firehelm?
I do.
And to be clear, would you agree that this is a chain email or correspondence between you and your co-counsel, Mr. Sabers?
Yes.
And would you agree that both of the messages depicted here fell or came from, were sent on Thursday, April 4th, 2019?
Yes.
So starting with your message, which is the smaller paragraph section on the second half of the page, you wrote to Mr. Sabers that you expressed concerns about irregular injury patterns, marks on the hands and arms, the large abrasion on Amy Mullis's chin or jaw. Those are one of the concerns you shared, right?
Yes.
You also mentioned that you had reviewed at least her medical information and the specifics about a bruise on her arm that was from an IV site from a medical procedure she had days before she died, right?
Yes.
So you had accounted by this point for her various injuries that led to her cause of death?
Yes.
And again, this is when you also were evaluating the potential claim of defensive wounds or injuries that were not from the puncture wounds to her back from the corn rake.
Correct.
This also notes that you went to go visit Mr. Mullis in person, right?
Yes.
And if you go to the third paragraph, it also shows that you reviewed the statements taken by individuals that you were asked about on direct, including Patricia Christofferson, right?
Yes.
And an individual by the name of Jerry, who ultimately was a subject of the case, or Jerry Frazier, is what you came to understand, right?
Yes.
So at this point, is it safe to say you were looking at this case from other potential suspects, right?
Yes.
And matters that of what happened months before even this case began.
Yes.
And so you knew about people who were supportive of Amy Mullis, for instance, or her friends in their statements, right?
Yes.
And you knew that they would potentially testify in this case too. Fair?
Yes.
If you flip to the second page of State's Exhibit G as well, there's a message dated also from April 4th there from your co-counsel, Mr. Sabers, directed towards you as well, correct?
Yes.
And in that message, you also discuss the autopsy report and accompanying photos, correct?
Correct.
And you even discuss down to the depth or distance between certain wounds, correct?
Yes.
And as we noted from your prior message, you shared a lot of these concerns, but these would potentially come to fruition to say that there was potentially more than one strike or swing, I think is how it was referred to on direct, right?
Yes.
I'm sorry, can I, objection, what portion of G are you looking at?
Objection, what?
Page 2?
The page 2, the full
Where does
paragraph of text.
What line says swipe or swing?
Oh, that was a paraphrase, a characterization used from the direct examination testimony, Your Honor.
I'm going to object to a characterization of swipe because I don't think that word was used.
Okay, I guess the record will speak for itself. We'll move forward with a new question, I believe, at this point, unless there was one pending. Mr. Duden, did you think you had a question pending?
Possibly, maybe, I don't know. I can ask another question.
All right, let's do that.
When we had discussed a swipe or a swing, for instance, what we're really referring to is the puncture wounds, right?
Correct.
And those would be known as the 6 wounds caused by the corn rake to the back of Amy Mullis's body.
Yes.
Looking to the responsive message from Mr. Sabers to you on page 1, that big block of text, do you see that?
Yes.
And in this text, if you'd like to review it, you also noted, you substantially discuss Jerry, right?
Yes.
And the other individuals, including a possible sheriff's deputy who Amy Mullis would have had an affair with, right?
Yes.
So is it safe to say that even at the earliest point of this case, you were considering other people who could have murdered Amy Mullis?
Yeah, this was very early on, beginning of April.
If you look down as well, you let me know when you see the information regarding the DNA evidence.
I see it.
In the individual at the latter third or so of that block of text, it says, quote, I doubt that investigators did anything by way of looking for DNA in there. And by now I suppose the scene is compromised, close quote. Did I read that correctly?
You did.
So at this point, you were also considering scene integrity, fair?
Oh, yes.
And you were considering the avenues of
just reading that letter. Holy cow.
Faulty investigation or a less than thorough investigation. Is that fair?
Sure.
Which is things that you brought up at trial, actually, right?
Yes.
And again, continuing on there, Mr. Sabers came on the case before you, correct?
Yes.
And at that next sentence, he says to you, quote, in my prior musings, I concluded that eventually finding fault with the shortcomings of their investigation would eventually be the route to follow, as opposed to hiring someone else to process the scene, right?
Yes.
So when we talk about processing the scene, we're really talking about evaluating the scene for alternative theories or looking for additional evidence, right?
Correct.
And so at this point, you and your co-counsel had considered this as a choice, right?
We did.
And so things like an accident reconstructionist, for instance, or an evaluation probably wouldn't have been on your mind as viable avenues for the defense.
It was not.
Now, you were asked about a biomechanical engineer specifically, weren't you?
Yes.
That letter alleges there are more marital problems than just the 3 that we knew about.
Oh, and I'm sorry, I do just want to talk about it. There was one more sentence that I figured I'd go ahead and cover with State's Exhibit G. The last sentence of Mr. Sabers' reply to you reads, quote, that mark on Amy's chin looks like she went down onto something like the auger, close quote. Did I read that correctly?
You did.
So you knew about a potential avenue of whether or not the auger was involved in causing Amy's injuries.
I can read it for you later on.
Yes.
And you also knew or were considering whether or not the fall to or the mark on Amy's chin was due to a fall injury, right?
Yes.
But it's fair to say, like before, you didn't believe that a fall was a viable avenue or claim, right?
That's correct.
And that's with more than 4 decades worth of experience predominantly focused in criminal defense, right?
Yes.
So again, returning to the discussion of a biomechanical engineer, have you ever worked with a biomechanical engineer?
I don't think I ever did with someone that had that exact title, no.
And so, have you ever heard of a case in the state of Iowa, where criminal case in the state of Iowa, where a biomedical or biomechanical engineer would provide testimony?
Sure, I read all the appellate decisions and belong to IAJ where we trade information like that.
So being aware of their work and the type of work that a biomechanical or biomedical engineer would do, you knew of that, right?
Sure.
And based on your experience and judgment, you did not believe that it was a viable avenue to do a scene reconstruction, for instance, here, right?
I did not. That's correct.
But looking to State's Exhibit H now, you and your co-counsel, again, were considering potential expert testimony in this case, right?
Yes.
In fact, you considered having the medical evidence reviewed by maybe an independent medical examiner or an expert witness in your case, right?
Yes.
Looking to what is the May 2nd, 2019 email message between you and your co-counsel, Mr. Sabers, do you see the message with the title subject being R.E. Bond?
Yes.
That first paragraph says, quote, we can and probably should have the autopsy report reviewed, regardless of our opinion that it was not an accident. Did I read that correctly?
You did.
So in this instance, you were also considering it from the perspective of whether an accident was potentially viable.
Yes.
And is it safe to say that that claim was coming from things Mr. Mullis had told you, as well as potentially his family or support system?
It was, yes.
But as your investigation progressed, the medical information didn't seem to be necessary for you to retain your own expert, correct?
That was our conclusion, yes.
Is it fair to say, based upon the number of times you discussed it, that you actually did contemplate or research reaching out to an expert?
Sure.
And that avenue was either not proceeded with or was otherwise fruitless, right?
That was the conclusion.
Early on in the case, though, as you mentioned, I believe, or at least in your prior notes, that a bond review or lowering Mr. Mullis's bond was a primary focus at the start of the case, right?
Correct.
You spent a significant amount of work on attempting to lower Mr. Mullis's bond, right?
Yes.
In fact, you even filed for an interlocutory review or an interlocutory appeal to have the Supreme Court attempt to allow you to lower his bond, right?
Yes.
And this was noted to be a significant concern for Mr. Mullis, wasn't it?
He was extremely stressed about being in jail.
In your interactions with Mr. Mullis, he regularly was stressed about either being in a jail setting or incarcerated or the case, right?
He was, yes.
In looking down to the next message on State's Exhibit H, which was from your co-counsel to you, sent on May 1st, 2019, do you see that?
Yeah. Got an update from Selena. She asked me
in
to pass
this
on
message, based on your review, is it fair to say that Mr. Sabers or yourself had provided Mr. Mullis with the reports of law enforcement officers or investigators in this case?
I think Bob took those to him, yes.
And in fact, you and Mr. Sabers had expressed your questions or attempted to answer his questions too, right?
Yes.
But at this point in time, starting with the third sentence of that message, let me know if I read this correctly, Mr. Firehelm. Quote, he told me that he doesn't want to read them because his anxiety goes through the ceiling when he reads things and he can't function. Did I read that correctly?
You did.
And again, in this message, is it fair to say that you are aware of Mr. Mullis's concerns or belief that this was possibly an accident, but that he wanted to rule it out at this point in time, right?
Yes.
And ultimately at the case, he didn't tell you not to proceed with conceding that this was a murder, right?
Objection. There's no foundation for that.
Overruled. The witness can answer if he's able.
I don't recall Todd ever ruling that out. Well, would you state your question again? I may have misstated.
Sure. So Mr. Mullis believed that this was an accident early on in the case, correct?
Correct.
And he held out to you that this was a possible accident at all times, fair?
Yep.
But by the time of trial came around, Mr. Mullis himself even testified that this was a murder case, wasn't it?
I believe he did.
And so, in that point in time, prior to trial, you had prepared Mr. Mullis for taking the stand, correct?
Yes.
You intended to engage in a review of the evidence to allow him to tell his side of the story, fair?
Yes.
And at that point in time, on cross-examination, on the last day of trial, Mr. Mullis, in fact, conceded that this was a murder. Fair?
I'm going to object. I think the transcript would speak for itself, and the transcript is in the record. I believe that what counsel's referring to is cross-examination, and he's misleading or mischaracterizing the testimony of Mr. Mullis and the questions that were being asked of him regarding the evidence presented at trial and whether Mr. Mullis agreed that evidence was presented that was a homicide versus an accident?
Well, certainly I'll have the opportunity to review the entire transcript and this section in particular. Mischaracterizing that testimony certainly isn't going to be helpful if that's what's happening. So the objection's overruled. Do you remember the question, Mr. Firehelm?
No, Your Honor.
All right. We'll have Kelly read it back since there was an objection, but you'll need a microphone.
Quick
Kelly,
update from Selena K. She's at the hospital awaiting a CT scan on the head, an x-ray. Think she's torn some knee ligaments. Checking for brain injury. She's really nervous.
And at that point in time,
she says, thank everyone for your prayers and pass the news on. She's scared.
Trial, Mr. Mullis, in fact, conceded that this was a murder. Fair?
I believe that's correct.
Your Honor, to clear up something, may I go ahead and present? Mr. Firehelm, I'd like to show you what's previously been indicated as Volume 5 of the trial transcript and what's previously been admitted into evidence as Exhibit 351, I believe. Directing your attention to page 56, beginning at line 12, the prosecutor asked Mr. Mullis, and somebody came onto your property right under your nose and killed her being Amy, right? That's what you're told? To which Mr. Mullis responded, that's what I'm told, right?
Yes.
And then the state asked Mr. Mullis, quote, and you know that's true now because you heard all the testimony in this case, right? To which Mr. Mullis said, yes. Did I read that correctly?
You did.
And the prosecutor next asked Mr. Mullis, you know that somebody took that corn rake and stabbed Amy in the back 2 or 3 times? To which Mr. Mullis said, yes. Did I read that correctly?
You did.
You now know this wasn't an accident, to which Mr. Mullis said yes. Did I read that correctly?
Yes.
So we knew where we were at trial, as did Mr. Mullis based upon his testimony. Is that a fair understanding?
I believe it is.
And again, this is from if you know, this is from Mr. Mullis' sworn testimony while under oath, correct?
I believe it is.
Now, speaking of preparation for testimony, you believed Tristan Mullis' testimony was essential to this case, didn't you?
I did.
Is it fair to say that you understood Tristan to be an alibi for Mr. Mullis?
I did.
But shortly before trial, there was some break in Tristan Mullis' statements regarding how long Mr. Mullis was out of his sight, right?
That's correct.
Tell me a little bit about that. What was the concern?
We deposed Tristan at Al Parrish's law office. I believe Todd, I don't know if it was video or just audio, but he was listening in. And Tristan gave his testimony as to being in the barn with his mother and father, or his mother leaving, and him staying there, helping his dad, helping Todd clean things up and make repairs and such. He testified that he went into the kind of a work area at the front of the building, I believe to get a drink of water, and then went back in the building, the main part where the hogs would be, where he saw his dad again. And he gave an estimate of how long he would have not been able to see his dad. And it was quite short. I can't remember, 30 seconds or something, long enough to get a drink of water.
Now, is it fair to say your understanding was that Tristan's testimony stated that Mr. Mullis could not have murdered Amy Mullis because he wasn't out of Tristan Mullis' sight long enough to be able to commit the crime?
That's basically it, yes.
During the course of your investigation and prior to trial, however, Tristan Mullis' testimony changed, didn't it?
Yes.
In fact, at his deposition, where he was represented by his own counsel, Tristan Mullis' testimony, for the first time while he was under oath, changed to say he couldn't recall a specific amount of time, right?
I believe so.
And that's ultimately the same sort of statement that he made at trial, if you remember, right?
I think so, yes.
Where he was also under oath. Fair?
Yes.
Was this shocking to you when this occurred?
Yes. In some ways.
Because I believe, as you stated earlier, Tristan's testimony was critical in this case, yes?
Yes.
But you worked hard in order to try and convey that Tristan Mullis was still with his dad for the bulk of the time in that hog barn on the day Amy Mullis was murdered, right?
Yes, that was critical.
You asked him questions specifically about possibly the number of times that he would have gotten a drink of water or been out of the sight of his dad, right?
Yes.
You asked him about family dynamics between Mr. Mullis and Amy Mullis, didn't you?
I think so, yes.
And I believe you, correct me if I'm wrong, but was the goal to convey that Mr. Mullis and Amy Mullis were in a loving marriage and that they were a happy family?
Yes.
And you made that effort to convey this central theme with each of the state's witnesses who would potentially say something different, right?
I think so, yes.
And if you recall, during some of the witness testimony, you asked about showing they worked on their marriage through marriage counseling, for instance, right?
Yes.
That they took trips together to places like potentially the water park, fair?
Yes.
And that they were working on their marriage and being supportive. True?
True.
And I believe during your cross-examination, perhaps of Ms. Stainer, you mentioned the messages that specifically related to Amy Mullis calling Todd Mullis super dad, or something to that extent, right?
Correct.
So at all times, you were working to convey not only a happy family approach, but also an approach that Mr. Mullis was a loving husband and father, right?
Yes.
And at least by the end of trial, you had even worked on reviewing those messages to keep instances of potential violence or prejudicial acts like was present potentially in Ms. Stainer's messages, for instance, out of the jury's view. True?
Yes.
And that's because you not only believed your client was innocent, but you were working to convey, a solid narrative of a united family. Is that fair?
Fair, yes.
Looking to the trial, when Mr. Mullis took the stand, do you recall asking him about the hunter safety course that his daughter was a part of?
I think we did, yes.
And directing your attention to what I believe is trial transcript volume 4, which has been previously admitted as exhibit 350 in this case. And directing your attention to what is page 170.
Selena sent me pictures of the cute firefighters that were attending her just now. Which is funny.
In scrolling down to the second half of the page, I believe, one moment.
She's got some medication, though.
Looking at line 10 to line 14, you asked Mr. Mullis specifically if he had Googled about cheating wives or cheating spouses, didn't you?
I did.
And he denied it on the stand, didn't he?
Yes, he did.
And similarly, going down to the next two lines, Mr. Mullis denied knowing who would have looked that up, didn't he?
He did.
I'll let her share the
Looking
pics
down
after
to
she
the
gets better.
second half, beginning, I believe, at line 22 to 24, you also asked him about potential TV shows or channels that they would have watched as a family, right?
I did.
And potentially, you also asked him, going on from line 25 to the next page, about whether or not those searches could be follow-up searches on those shows, right?
That's correct.
Similarly, you evaluated or considered how they enjoyed history and of the Native Americans or Indian populations, right?
Yes.
And that there was evidence that they would watch not only shows about this, but potentially searches would align with these topics. Fair?
Fair.
Now, scrolling to what is page 174, beginning at line 14, you also asked Mr. Mullis to explain potentially some of the searches that related to starving to death, drowning, floating, those kinds of things, right?
I did.
And you allowed, or Mr. Mullis had the opportunity to say under oath that those topics were more normal, or when considered in context, were not indicative that he committed a murder, right?
That's correct.
You also, looking to line 22 of page 174 of the transcript, you asked about chest wounds, gaping chest wounds, surviving in the cold, and other survival tactics or habits, didn't you?
I did.
To which Mr. Mullis answered, as we see mostly on page 175, that she was engaging in a hunter education program, an online thing, and that she was studying for it, and him and Amy Mullis were helping her review those educational course materials, right?
Yes.
And by her, I mean your daughter specifically. In this case, I'm sorry, Mr. Mullis' daughter specifically. We're late in the day, obviously.
Correct.
So you also asked about the hunter safety course materials specifically that have been, relevant not to just to this proceeding, but what was the underlying Google searches too, right?
Yes.
In fact, when you crossed Deputy Himaseth, I believe, then Deputy Himaseth, on the Google searches specifically, you asked him to review things from K Jewelers and other things like Pinterest, for instance, too, didn't you?
I did.
And in your closing arguments, you mentioned specifically that these things suggested the iPad in question or the Google account itself were not just used by Mr. Mullis. Is that fair?
Yes, it is.
So you sought, is it fair to say, to categorize your work in this case that you attempted at every turn to mitigate the Google searches and the state's narrative of what they represented?
That's correct.
They're doing a good job to show that he was a effective.
Taking you back again to a pretrial evaluation and how it impacted your trial tactics. You were asked on direct examination about whether or not you were looking for witnesses to testify to Mr. Mullis's good character. Do you recall that?
Yes.
But you were actively in contact with his family, weren't you?
Yes.
And individuals like Tom Krogman, for instance, who were mentioned, were also interviewed by DCI as well, weren't they?
Yes, they were.
And in those reports that you received and provided, in fact, to Mr. Mullis, you would have considered his role in the case. Is that fair?
Yes.
And that would be both as a potential person to help you investigate the case and as a potential person to testify on Mr. Mullis's behalf, right?
Yes.
But ultimately, as a matter of trial strategy, you chose not to call Mr. Krogman. Fair?
That's correct.
For that question, I think it's improper to ask if it's a matter of strategy when the witness hasn't testified that there was strategy in not calling Mr. Krogman.
Overruled. The answer will remain in the record.
She stumbled over that objection a little bit.
So, knowing how things impacted the case as it proceeded to trial 2, you were asked several questions about the 911 call. Do you recall that?
Yes.
Now, in all cases, you actually listened to the 911 call before trial, didn't you?
I did.
And it was a part of your overall investigation and discovery into this case. Fair?
Yes.
Did you also speak with Mr. Mullis about the 911 call and what happened prior to leading up to Amy Mullis's death?
I'm sure we discussed it, yes.
And to your understanding, is it fair to say Mr. Mullis conveyed to you that he didn't see how Amy Mullis died?
He said he didn't see how she was injured.
But he did tell you that he had pulled the corn rake out of Amy Mullis's back in order to be able to transport her to the hospital.
Can we get objection to foundation? When did Mr. Mullis say that to Mr. Firehome? What's the underlying context?
Mr. Duden, would you like to lay some additional foundation?
Sure. Early in the case, did you ask Mr. Mullis what happened leading up to Amy Mullis's death?
Absolutely.
Would that be prior to you determining what course of action or case theory you wanted to proceed with to trial?
Yes.
Would that be early on, say even before the trial information likely was filed in this case?
Probably so, yes.
So it was an early, is it fair to say that it was an early topic of discussion between you and Mr. Mullis?
Yes.
Having listened to the 911 call, that call ultimately came into evidence, correct?
It did.
And prior to Mr. Mullis's cross-examination, you had no reason to believe that the state would argue that the muttered statements under his breath that were claimed to be there were present, did you?
Had no idea.
But in response to those statements being alleged by the state, in your closing argument, you attempted to undermine the value or the claim that the statements about Amy Mullis being a cheating whore or telling her to, quote, die cheating whore was on the record. Is that fair?
Yes.
Oh, I believe it was, quote, go to hell cheating whore. I apologize for that statement. In those statements, you believed that there was heavy breathing.
Let me correct the record. Go to.
In that you believed he was working to revive his wife. Is that a fair assessment?
The apology.
Yes.
Your arguments at each time said that the state's asserted claims were false. Is that right?
That's correct.
Now, primarily as it relates to the heavy breathing, you were shown a potential transcript of a 911 call. Do you recall that?
Yes.
And in that transcript, when you read, do you recall reading from it?
When it was shown to me yesterday, yes.
And if you remember, in that transcript, they indicate there's things like heavy breathing, right?
It did.
So in fact, your claims or your arguments presented at closing were fairly consistent. Is that right?
I believe they were.
But is it your opinion that that ultimately came down to a weight or credibility determination for the jury?
I believe so.
And ultimately, after the trial came back and the jury found Mr. Mullis guilty of murdering Amy Mullis, you moved for a new trial and judgment, or to arrest judgment. Do you remember that?
Yes.
And you allege that it was misconduct, in fact, to claim that those statements were made on the 911 call. Fair?
I believe it did, yes.
And so you sought to preserve that claim and also to ensure that Mr. Mullis had the fairest trial he could have, in your opinion, right?
Correct.
Now, in your more than 40 years of experience as a criminal defense attorney mostly,
welcome.
Have you had transcripts of 911 calls be completed?
Certainly.
I like it.
Have you done that yourself?
This is spicy.
Yes.
Did you believe it to be necessary in this case?
No.
And to be fair, your arguments were to what was being said under someone's breath rather than overtly in the statements heard on the call. Is that a fair assessment?
Yes. It's my understanding that, and this was told to me by the prosecutor, that this muttering under and saying those terms was called in by someone watching on court TV, and that's how it came about.
So you weren't really assigning a lot of weight to these claims, is that fair?
That's very fair.
Did you ultimately review the Court of Appeals decision in this case?
I did.
And to your knowledge, did that opinion or ruling speak to the potential substance of the 911 call?
I think there was a footnote to that, about that, yes.
And if you recall, or correct me if I'm wrong, do you believe that that went, like you believed as well, to weight rather than a matter of fact, for instance?
Yes, I agree with that.
And that ultimately is how you proceeded in this case, right? You argued it in closing rather than sought to omit it from its admissible use.
Yes, that's correct.
And you attacked its use even after the trial.
Yes.
It wasn't me.
Correct me if I'm wrong, too. At the time that then Deputy Himiseth took the stand at trial, you even asked him about UTC time, too, didn't you?
I did.
And in that line of questioning, you talked about cell phone extractions and the specific information at hand to the electronic devices like the iPad, right?
Correct.
And your course of action, is it fair to say that it was a strategic decision to proceed with attacking his credibility when you so that you could argue what he said didn't make sense?
Exactly.
And that is what you actually did in closing too, right?
Yes.
Mr. Firehelm, you've reviewed digital forensics information before, right?
I have.
You've reviewed electronic discovery before too, right?
Yes.
And that would include even evidence from a Cellbrite phone dump. Yes?
Many times.
So you knew how to look at the records and electronic information provided to you as a part of the investigative file from the state shared during discovery, right?
I believe so.
And you talked through that discovery and those investigative files with Mr. Mullis, didn't you?
Objection.
We did.
I don't think there's been any foundation that a conversation was ever held with Mr. Mullis regarding whatever piece of electronic evidence the state is trying to ask about.
Well, certainly there was testimony that counsel reviewed discovery materials with Mr. Mullis. Objection.
Did he answer? During those periods of time, do you recall Mr. Mullis ever mentioning planting being an evaluation during as to why he wouldn't have been able to make those searches?
That he was planting crops?
Yes.
Is that what you mean? Yeah, he talked schedule of long, long hours and working into the night.
But he never proffered it as a reason for why he didn't use the iPad, right?
Right.
And you didn't view it from the claim that that would have made it so he couldn't access the internet, true?
Correct. Right.
And in fact, when you asked him about it at trial, when he was on the stand, planting was not a reason that was provided as to why he couldn't have made those searches, right?
I think that's correct.
But still, he denied that he even conducted those searches, fair?
Yes.
So at no point in time did Mr. Mullis, to the best of your recollection, did Mr. Mullis or his family ever provide that as a proffered reason why he could not have done the Google searches, fair?
I think that's fair, yes.
Looking to what's previously been admitted as Exhibit 233, which I know has been the subject of communication previously. Hold, please, I apologize. One moment while we get that pulled up for you, Mr. Firehelm. Do you see Exhibit 233 on the screen, Mr. Firehelm?
I do.
Now, going to that last paragraph, I believe you had testified on direct examination that Mr. Mullis's inquiry about a possible quote-unquote expert, you believed it to be just shotgunning. Am I right?
Yes.
And if I understood your testimony correctly, and please correct me if I'm wrong, this was because you and Mr. Mullis had evaluated different kinds of defenses and different ways to proceed at trial well before the trial ever took place, true?
That's true.
And this included what witnesses to call, including any potential need for an expert witness, possibly.
Yes, that's correct.
But looking at this page, if you don't mind scrolling to the top, thank you. On 233, do you see where it begins at number 18?
Yes.
So in this line, is it fair to say that this looks to be an incomplete list?
Yes.
And this exhibit actually doesn't have a date on this note specifically, does it?
I don't see one.
Do you even know when this note would have been sent to you?
I would have no idea.
How, other than the notation of legal up top, would you know that this was meant for you?
That would be my guess, that if he wrote legal on there, that the jail would let him mail it or something. I don't know.
Well, knowing that, Mr. Firehelm, I'd like to scroll and draw your attention to what I believe is page 2 of this exhibit. Does this page have a date either?
I don't see one.
So, like before, you don't know when you would have received it, if at all. Is that fair?
That's correct.
And you don't know when it would have been sent or what it would have been about. Is that fair too?
That's fair.
Now, if you want to go ahead and review a little bit of this text, Mr. Firehelm, specifically the first 3 sentences, I'd like to ask you about the context of what this letter shows for you.
Find this sheet, but spelled with an I. Travis said about all computer stuff being made.
Now, when you're going through this message, do you know that there's various individuals and different witnesses that the state called at trial?
I guess it boils down to Tristan and his testimony.
And conversations about the inclusion of, say, porn or the testimony of someone being critical, this case being Tristan, was important for not only trial purposes, but also for your case, right?
Yes.
Is it fair to say that you cannot with certainty say that this case or this letter was not received or, an insight after trial, for instance?
It could have been. I mean, I can't tell. I'm just looking at it.
In fair point. So there's no way to know when this would have even been sent to you, if it was sent to you at all, right?
That's correct.
Now moving to the next page of the same exhibit, what is page 3, I believe. Focused on the screen, the first word on that screen, if I'm reading it correctly, is Lynn, correct?
Yes.
Now, I don't mean to, play games here, Mr. Firehelm, but is your name Lynn in any case?
No.
Is this any indication that this letter was even sent to you?
Doesn't look like it was.
So it's fair to say that it was actually not even a letter to you at all about the case, right?
That's quite possible.
And going to the next page, page 4, and I don't mean to beat a dead horse with this or anything, but this one's also addressed to Lynn, right?
It is.
So much of this document, if we'd like to proceed to the next page, for instance, or some of the others, would suggest that, again, I believe Lynn is the name shown in the top corner with a date, actually, on this copy, right?
Yes.
And that date is August 29th of 2019, right?
Yes.
So this letter, too, was not addressed to you, right?
It appears not, yes.
So looking back on it, these ideas and insights from Mr. Mullis were not likely provided to you. Is that a fair assessment?
I don't remember seeing these, no.
So much of these ideas are either unbound in time or you're not the addressed recipient or intended recipient of this. Is that fair?
It's fair.
But drawing your attention to the other evidence in this case, and I don't mean this specifically anymore, you discussed the DVR cameras or the security cameras on the Mullis farm too, didn't you?
Yes.
And that was on direct examination. You discussed how potentially those cameras would have gone out, right?
You mentioned a foundation. Direct examination of who?
Your direct examination.
Of Mr. Mullis?
Mr. Fire.
Oh, sorry.
Literally just minutes ago.
I withdraw that, yes. Okay.
Withdraw.
And just for clarity of the record, during the direct examination of you, Mr. Firehelm, shortly before, you discussed those DVR security camera recordings, right?
Yes.
But that direct examination wasn't the first time you actually discussed those cameras, right?
Correct.
At trial, do you recall that you alleged, like Mr. Mullis had told you previously, that potentially the cat had knocked it off or interrupted the signal? Is that fair?
Todd told me that, and so did his brother Mike, and maybe even Lynn, too. I don't know.
So you investigated that evidence, didn't you?
Yes.
And you took not only Mr. Mullis at his word, but the support system that he had in place of his family too, right?
Yes, and I went and looked at it, and oh, maybe I shouldn't volunteer. I'm sorry.
Well, I'll go ahead and ask the next question. What is your insight on this issue specifically? What were you just going to say?
I don't know. Ask your question.
I grew up on a farm with dairy cattle and cats and corn rakes and so forth. I was proud of myself as an attorney when I walked into the courtroom and talked to jurors and argued cases to have that practical experience. And when I walked into the shed and looked at the window and how it was situated, cats like to lay in the sun. I think that window faced west in the winter part of the year. All these things make sense. So that's what I meant. I'm sorry.
And again, you believed in your client's innocence through the trial, didn't you?
Very much so.
And you argued till the end of your representation that Mr. Mullis was not the one who had murdered Amy Mullis, right?
I did. That's correct.
But you knew what evidence would be essential to your case, didn't you?
I did.
And that critical piece of evidence was going to be Tristan Mullis' ability to provide an alibi for Todd Mullis at the time, correct?
Yes.
So when he changed his story specifically, or when he was potentially not going to be available to testify, you brought that to the judge's attention, didn't you?
I did.
Drawing your attention to what's previously been marked and admitted as State's Exhibit I. Let me know when you have it in front of you, Mr. Firehelm.
I have it right here on my desk.
For clarity of the record, Judge Bitter was the judge who presided over the case at the criminal trial level, is that right?
That's correct.
And so this email is dated August 13th of 2019, correct?
Yes.
And so this lengthy email with representatives of the state as well as for Tristan Mullis and your team too were included on this message, correct?
Yes.
And in this message specifically, you inquired about whether or not waiting for Tristan's potential issues addressed with his counselor to be addressed sufficiently so that he could testify at trial, right?
Yes.
And in order to ensure that he testify at trial, you floated the idea of a continuance to Mr. Mullis, didn't you?
I did, sorry.
And in speaking with him about this, Mr. Mullis was adamant that trial should proceed as scheduled, wasn't he?
Very much so.
And so he was opposed to continuing the trial date, and that was your position too, wasn't it?
He was opposed to it.
And at this time, trial was set for September, right?
Yes.
So in the interim between this email and when you began trial, you deposed Tristan Mullis, didn't you?
Yes.
And that was when his story changed, yes?
Yes.
But you proceeded to trial in September because Mr. Mullis did not wish to ask for a continuance, right?
That is correct.
So when we look at that September timeline, you were also asked potentially about whether or not he would have a fair jury that, at least my understanding would be, would include potential farmers as well, correct?
That's how I understood it, yes.
But it was Mr. Mullis who wished for the case to proceed that month, right?
Yes.
In that month, I mean harvest season, true?
Yes.
And you were following the directions of your client, is that fair?
Yes.
So you proceeded to trial, but you had previously moved for a change of venue, right?
Yes.
Now, with about 40 years or more now of legal experience, is it fair to say that you know a judge would decide what venue to send it to rather than the parties specifically shopping for one?
Objection to the characterization of shopping in the state's question. It's inflammatory and prejudicial.
Would you like to revise your question, Mr. Duden?
Sure. Mr. Firehelm, in your experience as a lawyer with more than 40 years of practice under your belt, do attorneys get to choose what forum they go to when they move for a change of venue?
No.
They don't have the final say, no.
Is it fair to say that a judge would make that ultimate decision?
Correct.
And in this case, a judge decided to move the venue to Dubuque County, right?
Yes.
And at that time, the concerns were ultimately revolved around whether or not Delaware County and Dubuque County were in the same media market, true?
That was one of the concerns, yes.
But you had asked prospective jurors when selecting a jury about potential exposure to media and their biases, didn't you?
I did.
So you sought to address those concerns to ensure your client would get a fair jury or a fair shake, right? And ultimately, when the jury was selected, did you have concerns about there being a fair cross-section or whether or not more representation of farmers or anything like that were going to be dispositive in this case?
No, I thought that this panel during voir dire was one of the more cooperative ones that I had encountered in trials, and I felt the cross-section was pretty good, actually.
So, in your opinion, the selection of the jury was fairly good for the case that was at hand?
I did, yes.
And to your knowledge, at any point in time, was it conveyed to you that there was a concern about a lack of a fair jury or cross-section being selected?
I don't recall. Once we got going and the jury was picked, no, I don't recall any concerns by Bob or me or Todd.
So is it fair to say that it wasn't really a concern for you and the Mullis defense team?
I think that would be fair, yes.
You had spoken at length about Jerry Frazier while on direct examination in this case, correct?
I think so, yeah.
And specifically, at trial, were you pointing to Mr. Frazier as a potential person who would have motive to kill Amy Mullis as an option?
Yes.
You weren't necessarily saying that he was the murderer, were you?
No.
You were in fact pointing to many other people who could potentially have reason to commit the act, right?
Yes.
And again, at all times, you were maintaining the narrative that Mr. Mullis did not commit the act in question, yes?
Correct.
That he didn't murder his wife.
That's right.
Whoever's technical director on this production is trained in the news media. I like the quick cuts. We've had one poll already after the
now, my
direct
understanding,
questioning.
Mr.
We'll do
Byron,
one
based
more at
on
the
your
end
prior
of
deposition
cross.
testimony, is it fair to say you view the role of a defense attorney as one to sow doubt or reasonable doubt into a case rather than to prove the alternate versions of a crime, right?
Exactly.
That the burden is the state's to prove that a crime was committed, in this case a murder, not your burden to disprove it.
That's correct.
And so, in this case specifically, you were looking to provide potential other avenues that would sow that doubt in this case or help you secure a not guilty verdict for Mr. Mullis, right?
That is correct.
Mr. Firehelm, in your experience, would you say that you provided zealous advocacy for Mr. Mullis in this case?
Objection to the vagueness of zealous advocacy, and it's inappropriate to ask Mr. Firehelm to judge his own performance.
Overruled.
How would you rate your performance out of 10?
Once again, I pride myself that, especially with the jury trials, that these situations for my clients are extremely stressful, important to them, in Todd's case, the most stressful, facing a life sentence. And I don't take that lightly, and I believe I did everything within the time frame that we had, that I did everything I could to obtain that verdict of acquittal.
Interesting body language with that answer.
I guess is one of the last things that we need to talk about. Did you advise Mr. Mullis on his rights as it related to his ability to testify or not?
Yes.
Before trial, before he took the stand, did you work to talk through his testimony and help prepare?
Yes.
And in your professional opinion, or do you recall any instance specifically to which Mr. Mullis would have expressed concern or doubts about any of the process for him to take the stand?
I don't recall specifically. I mean, clients frequently say, I don't want to blow it. I'm nervous, those kinds of things. But I don't think Todd, it wasn't like we had to drag him to the stand. And frankly, I thought he did a wonderful job.
So just to confirm, you didn't encourage Todd Mullis to plead guilty?
Correct.
You didn't advise him that he should waive a jury trial?
No.
You didn't tell him not to testify on his own behalf, or that he should, one way or the other, really, did you?
No.
You didn't force him to take the stand, right?
No.
And you never encouraged him to forego an appeal, did you?
No.
To that end, was the choice to plead not guilty and maintain his innocence all the way through trial, did you help Mr. Mullis maintain that objective through trial?
As best I could, yes.
In the arguments that were chosen to pursue, the argument specifically was to pursue believing that this was a murder, right?
Yes.
And as a brief recap, you reviewed the discovery yourself with Mr. Sabers and Mr. Mullis, didn't you?
A number of times.
You deposed witnesses in this case to ensure you understood the different theories of the state's case as well as possible theories for your case, right?
Correct.
You always believed that your client was innocent and held out to the jury that Mr. Mullis did not commit the murder did not murder Amy Mullis, right?
I did.
And you worked to address the pitfalls and concerns of Google searches or electronic evidence, didn't you?
I did.
And you sought to make sure he was prepared and ready to proceed in maintaining his innocence and helping prove his innocence when he took the stand, right?
Yes.
Yeah, I've been texting with Selena.
I don't have anything further, thank you.
And you redirect.
I do, Your Honor. Would it be possible to take a very short break just to get organized, and then I'll be ready to go?
Probably just a real short break. I imagine we're running short on time, so.
Thank you, Your Honor.
Okay, we'll take just a few minutes. Council, let me know as soon as you're ready. Mr. Firehelm, again, I'll go ahead and just leave the Zoom running.
Don't touch anything. Don't touch anything. Don't break it. Quick update. Selena, when she first got injured, she sent me a picture of her laying on. She's literally a selfie laying on the ground. She did get injured, possibly some damage to a leg. It looks like no broken bones, but might be torn ligaments. And they're going to do a CAT scan as well to make sure there's no injuries to the head area and the brain. She says, I can update you with this. Otherwise, I would not be telling you these personal details. She says, thanks everyone for the prayers and passing the news on. I am scared. She told me the hospital she's at, and thank you. We've had another person reach out. Thank you very much for that. that's super kind to say, hey, I'm Nicole, by the way, thanks. Saying I'm close by if anything needs to be dropped off. I've asked Selena if she needs something. Usually it's something like a phone charger or flowers or Crown Burger or something like that. I don't know. And Nicole's volunteered saying if there's anything needed, let me know. Selena does have family nearby, so it looks like a fall on the stairs. And she was with us. She had her phone with her when it happened, so she texted in chat. You guys saw it. She reached out to me, and she called 911 and got taken to the hospital. So. Thoughts and prayers for her, and she says thank you, everyone, for that as well. Selena's been a longtime supporter and follower of the channel, so it can be scary. She showed up with one point. Yes, she sent me a picture of the firefighters. She's like, hey, there's some cute firefighters. So I've got a picture of that. I'm not going to show that. I'm going to let her share that maybe on Facebook if she wants to. But so it's good that she's at least in positive spirits, even though it's a scary time. So, all right. Silver linings. Yes, silver linings. It is almost 5 o'clock. When the judge says we're almost out of time, it means that we're almost done for the day. So any minute now, we're going to get some audio back. And when that happens, we're going to, we'll find out how this ends. I think we're nearly done with this witness. The state, the prosecutors who are the defense in this trial, have done a fantastic job at crossing this lawyer. And this is what I pointed to earlier. The bar to achieve, that you have to clear to show that your counsel was ineffective, is very high. And you can't achieve it just by saying, I don't like the strategy they used in court. The state has really been able to you push this around and make it look like it's just you didn't like this. You're mad because you lost is how it comes across now. Now, in the process of doing this, they have shared quite a few letters, emails, and this is interesting because we rarely, if ever, get to see this. This is privileged information which has been waived for the purpose of this trial. So the lawyers are sharing what they talked about amongst themselves, what they talked about with their client, what he said to them, what they said to him. And some of these letters I'm going to share with you, and just so you can get an inside view. See, Mr. Feuerhelm gets a letter from Bob Sabers, who's his co-counsel. Bob says this: I haven't sent it to the report expert yet, but will shortly. They apparently didn't give us the photos they took of Todd's body 5 days after the pursuant to a warrant, but Todd says he didn't have any cuts or bruising other than maybe a minor cut or two incidental to farming. Todd told me that aside from the family's interactions with each other, Jerry was the person they saw more than anyone else. Todd says he believed Jerry when he denied romantic involvement with Amy. He says Jerry was very persuasive. He'd probably be able to fool law enforcement. He's that good. Or how about Jerry's wife? Or the sheriff's deputy? Or Tristan? There's a couple of rumors out there in regard to the death of a guy from Manchester. He froze to death after driving off a rural road when we had the bitter cold weather in late January or early February. The rumors are that the guy was sleeping with Amy, and either the deputy who had the affair with Amy or Todd ran him off the road. I'm sure there's no truth to the rumor, but had Amy reignited something with one of the deputies she previously slept with? Who better to frame somebody than a law enforcement officer? I spoke to Lynn about returning an iPod of hers that she's previously left at my office, and then taking another gander at the red shed. Her mother thinks there's something in there that has been missed. She's having dreams to that effect. I doubt that investigators did anything by way of looking for DNA in there, and by now I suppose that the scene is compromised. In my prior musings, I concluded that eventually finding fault with the shortcomings of their investigation would eventually be the route to follow, as opposed to hiring someone to process the scene. That mark on Amy's chin looks like she went down to something like the auger. So this is just like raw discussion. Let me see. Let's go further forward. There are some other letters. There was one from Todd. I wanted to show you. But we have a spam call. Keep your fingers crossed. Maybe they'll talk to us. Here we go. Hello? 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 Can you talk a little louder? I can barely hear you.
This is Chloe speaking, calling you from the main fulfillment center at Wingate Travel.
Hello. How are you doing today?
Doing great. Man is calling you from the main fulfillment center at Wingate Travel. I'm calling you about the vacation package you bought before the pandemic. You remember that, right?
Oh, yes. Yes, I remember.
It's our package, yeah.
Are you still there?
Yes. No, I'm just calling you about the vacation package you bought before the pandemic.
Were you the one that helped me line that up?
No, Ern, what happened then? Why did you didn't use your vacation package before?
I was waiting for the taxi to take me to the airport, and they never came.
Sure. Okay, then I'm gonna call you this morning about that. Okay.
We're on the phone now. Somebody's okay. Look, I realize not everyone loves the job they do, but she does not. She did not want to do that job. She was on Facebook. She was doom scrolling. I don't know what she was doing. Let's see. So you like her voice? I should have done that. All right, we might be coming back to court here in just a minute. I was going to read another letter. Next letter is, there was one from Todd that I was going to read. Sorry, I do get sidetracked. I love to take calls from what I believe are scammers and give them a hard time, because I think that all the time I spend on the phone with them is time that they cannot be scamming somebody else. Looks like we're going back to court right now. Okay, come on. Where's the next letter?
Please be seated.
Back on direct. And I said yes
Ms.
twice,
Nichols
which was
Cook, are
terrible.
you ready to pick back up?
Yes, thank you, Your Honor.
All right, you may proceed when you're ready.
Mr. Firehome, you were asked on cross about an email that indicated Todd was stressed and having trouble reviewing discovery. Do you recall that?
I do.
To your knowledge, had Mr. Mullis ever been incarcerated before? And to your knowledge, was this the first time that Mr. Mullis was learning about Amy's affair with Jerry Frazier in the discovery?
I'm not certain that's true.
Did you do any investigation to figure out if that was true?
We talked about it, but what I'm being careful here is I'm not certain that Todd told us that he knew about it before this discovery material was reviewed or not.
Would you agree, though, it'd be upsetting?
Certainly.
Yeah.
Certainly.
I want to reference States Exhibit F, the email from April. I think you have that.
I do.
And in that email, it says we need to have an expert take a look at the autopsy. Is that what it means?
That's what it says, yes.
But you never did do that.
No.
Okay. Do you recall a note that was passed to you after your opening statement that said WTF on it?
Excuse me? Did it
I eventually saw it. I'm not sure when.
from Todd to lawyer? WTF?
Did you understand that to mean that your client didn't know what you were going to say in opening?
I'm not sure what was intended.
Did you talk to your client about it?
No, I don't think so.
And you would agree with me that Mr. Mullis never told you he believed it was a murder?
I'm not going to say he said those words, no.
Selena posted some pictures in the Facebook group.
You talked on cross about it was the state's burden to prove beyond a reasonable doubt that a crime had occurred. Do you remember that?
Yes.
And would you agree that in your opening you conceded a crime occurred?
Yes.
And would you agree that Todd always maintained it was an accident?
He always maintained that that was possible, yes.
And in your deposition, you testified that Todd never agreed with you that it was murder. Do you remember that?
I think that's what I said, yes.
You testified on cross that Tristan, you considered him to be an essential witness because he was an alibi. Do you remember that?
Yes.
Tristan's testimony was only essential if you believed Amy's death was the result of a homicide, right?
Yes.
You were asked about the change in Tristan's testimony in his deposition. Do you remember that?
Yes.
Did you do anything to present all of the prior statements Tristan had made before his dad was arrested that indicated he was with his dad the whole morning?
I think we did, yes.
You were asked about the Google searches and the electronic evidence. Do you recall that?
Yes.
And you've also told us that you prefer paper over electronic documents, right?
As far as maintaining the files and exhibits and discovery, yes.
And I've showed you several things today that come from electronic discovery that you didn't have before.
Yes.
I want to go briefly back to Exhibit 233 that the state showed you and asked you about as well. Do you recall testifying in your deposition that this was Todd's handwriting and a letter you received from him?
No, I don't recall those specifics, no.
Let me find the page for you here. Elena, you put it in the end. Okay, Mr. Firehelm, you have a copy of your deposition in front of you, right?
I do.
And for the record, it's our Exhibit 323. If you could look at page 19 and start at line 22. And read through page 20, lines 8 through 13.
Read to how far?
Page 20, lines 8 through 13.
Okay, I've done.
And does that discuss letters from Todd?
Yes.
If you would go back to looking at 233, and we'll scroll to the third page.
Did we sing to Angela Brown this
Do you
morning?
see a date there at the top?
Do we sing to Angela Brown?
I'm sorry, it's not the third page, it is the fifth page. My apologies.
Yes, I see that date, August 29th.
2019.
Yes, correct.
This would have been about a month before Mr. Mullis's trial?
About 3 weeks, yeah.
And you testified earlier that you spoke with Todd's sister Lynn a lot during your representation of Todd?
Yeah, quite a bit, yes.
And that Lynn would give you information as well?
Yeah.
And that she would call you or email you and say Todd needed to see you or talk to you?
That was common, yes.
If you go down to page 10 of 233, do you see the handwriting in the middle of the page at an angle?
Yes.
What does it say?
Lawyers first, then Lynn or Mike.
So is it entirely possible that this letter was sent to you?
Objection, speculation.
Overruled. The witness can answer if he's able.
Anything's possible, but I just don't think so.
Hey, Sharon, you just sent a request to join the Facebook
But
page.
you were representing Mr. Mullis August 19th, 2019. So you would have been
Resubmit.
one of
Answer
those
the questions
lawyers
at the bottom.
referenced on page 10.
I assume so, yeah.
Do you remember signing an affidavit regarding your representation in this case?
Yeah, I remember signing one, yes.
It's Exhibit 224. We can show it to you. I don't know if you have it.
I think I have it.
Can you see the one on the screen?
Yeah, I just found it. I have it in front of me.
Okay. You were asked about the 911 call that was played for Todd on his cross-examination.
Yes.
And in this affidavit, can you read paragraph number 10?
Objection.
I did not.
That's not in evidence, Your Honor. This is not an admitted exhibit, and consistent with the court's order on day one, affidavits have not and likely would not be admitted.
Your Honor, I was asking the witness to read it to himself. I apologize. That wasn't clear.
Okay, so for now at least, the objection will be overruled.
Let's see if I can read it.
Let me know when you've had a chance to read paragraph 10.
I have.
And do you recall me asking you earlier about whether you asked for move for a mistrial after that 911 call and the arguments were made by the prosecutor?
Yeah, I think you did.
And
Got some chocolate milk.
with all of the decades of experience, have you moved for a mistrial before?
Yes.
And do you agree that you could have and should have in this case?
In hindsight, I could have.
And in fact, you've said before you should have.
Right.
You were asked about conducting depositions leading up to this trial. Do you remember that on cross?
Yes.
You testified earlier that you didn't conduct any research or investigation before those depositions. Is that still true?
Research as to what?
Well, to prepare for depositions regarding the electronic evidence or any other topic?
I reviewed the discovery that had been produced.
Other than reading police reports, you didn't do anything else. Is that correct?
Talk to Todd, talk to Bob, Lynn, Mike, those kinds of things.
And you didn't consult any experts to help you understand the evidence?
Objection.
That is
answered within the scope of the direct and the cross, Your Honor.
Overruled. If there is an answer, it will remain in the record. Okay. I don't think there was. Mr. Firehelm, do you remember the question?
I started to say it. My answer was that's correct.
You were asked on cross about complying with Todd Mullis's wish to not continue his trial. Do you remember that?
Yes.
Do you disagree that you didn't comply with anything else that Todd asked you to do as far as consulting an expert regarding whether her injuries were the result of an accident?
Objection argumentative in the state's testimony.
Overruled.
I don't do my response to Todd's references to getting experts as ignoring him, or whether I complied with him. I think I've explained that before, how I viewed that.
You were asked several questions on cross about investigating issues. Are there actions you took that we have not discussed today?
I've got kids.
The only thing I can think of is in some cases, as a member of the Iowa Association for Justice and the criminal group of that organization, we have a pretty active listserv. So once in a while, an issue will come up, and rarely will the attorneys, and I'm one of them, will we give the name of a case or a client's name or something. But if it's an evidentiary issue or something like that, I think I probably did that in this case. I don't remember specifics, but that's one thing other than
so he phoned a friend.
What we've talked about, I guess.
Thank you. I wanted to follow up on the testimony by Deputy Himsath at trial about the timing of those Google searches. Do you recall that?
Yeah, kind of.
Do you know why you didn't impeach him? That he had the calculations of the timing of those messages wrong?
I guess I thought we did to some extent. I don't remember exactly how the record reads.
Do you understand how to do a UTC calculation?
Yeah.
So if you didn't impeach him, you don't have a reason for that?
I guess whatever I did, I did.
What else? What else?
I'll stand on the record.
Attorney's phoning a friend as well.
You were asked on cross about the hunter safety certificates and guide and the questions you asked Todd Mullis. Do you remember that?
Yes.
Did you obtain a copy of that guide and compare it to the Google searches?
I don't believe so.
Did you talk with Todd's daughter or Tristan about what types of searches they might have done?
I don't think so.
Did you only put Todd on to explain that, to testify?
Yes.
You were asked about your email in April where you believed it was murder based on your review.
Yes.
And you were asked about working with an accident reconstructionist or a biomechanical engineer, I think?
Yes.
Have you worked with an accident reconstructionist before?
Yes.
But you did not do that in this case?
Yes. That's correct.
Do you recall being asked in your deposition whether you had the consent of Todd Mullis to concede it was a homicide prior to making your opening statement?
I don't recall specifically, no.
If we could go to your deposition, page 22.
Is that something the lawyer would need consent to do, or is that
23?
just a trial decision, strategy decision?
Oh, line 23. Page 22, line 23.
Yeah, I see that.
And your answer to that question about whether Todd consented was no. Not like I'm okay with that. No.
That's what it says.
So any testimony you gave today that you think Todd knew is different than your testimony from your deposition?
Well, if that's the way you interpret it, that's not what I meant. What I testified to today, I think, is that I felt that Todd had acquiesced in that concept.
So, Mr. Firehelm, did you understand Todd to always maintain that it was an accident that injured Amy?
I'd have to answer that yes. Yes, but, I guess.
Yes, but. It's a big but.
But you did not present that theory or investigate that theory for him. Is that accurate?
Didn't present it. I'm not saying we did investigate it.
But did you talk to any experts about it?
Objection,
No.
Your Honor. This is asked and answered in cumulative to the record at this point.
Objection is overruled. The answer will remain in the record.
Your Honor. Oh, wait.
Any redirect?
Your Honor. I'm sorry, Your Honor, I have one more question. May I go back?
You may.
That was
Mr.
almost a
Firehome,
no.
in your opening statement, you told the jury that Todd's prior statements to law enforcement were wrong. Do you remember that?
If that's what I said, yes.
And then you put your client on to testify in your defense without any corroboration.
Whoa.
Objection, Your Honor. From just clarification of the record purposes, I believe that's necessary to say your defense, I believe, should be clarified if possible to Mr. Mullis's defense.
Your defense case.
Certainly that's the way the court understood it.
Thank you, Your Honor.
Do you want me to repeat or rephrase the question?
Please.
If the transcripts show in your opening statement that you told the jury Todd was wrong when he talked to law enforcement, and then you put Todd on in the defense in chief and expected the jury to believe him, that was what you did?
What I told the jury is that Todd told law enforcement that she fell, that it was an accident. That's what he initially thought. He testified on cross-examination that it was a murder. So I'm not sure what you mean, I guess.
I'll move on and follow up on that, and I know I have to be done. Todd's testimony at trial is reflected in the transcripts, right?
Yes.
And so if the prosecutor asked him, based on what you've heard at this trial, do you now know it's murder? Would that be different than Todd's belief that it was murder versus an accident?
I can't say.
Okay, and Mr. Mullis wasn't qualified to review the autopsy report or do an accident reconstruction to have his own belief.
I'm sorry. What was your objection? I didn't hear it.
Well, one, this is irrelevant, and it's not facts in contest, so it's immaterial and far more prejudicial than probative, because certainly no one is contesting that.
Well,
it's prejudicial because no one's contesting it. We're done for the day is what we are.
Getting a little far afield here. Sustained.
No further questions?
Any redirect?
Briefly, Your Honor. Permission to share the screen?
You may.
Perfect. Drawing your attention to what has been marked previously as Exhibit 350, and specifically drawing your attention to page 75, line 25. Do you see that, Mr. Firehound?
350?
Yes.
I want to talk to you about
so
some of the
it says,
times.
I want to talk to you about some of the times that you're given. What's UTC mean on this printout? That was your question to Deputy Himmelsath, wasn't it?
Yes.
To which you responded Central Standard Time, right?
Yes.
And you just say, if the internet tells you you're wrong, would you disagree? And he said, can you ask that again? I guess I've never had the internet tell me I'm wrong, which I believe is a joke or also just maybe in jest. In either way, have you ever researched that UTC is the successor to Greenwich Meridian Time, GMT? To which he responded, okay, I've never searched that, no, right?
Yes.
Now continuing down through page 77, line 5, let me know when you've reviewed it or if you need it slowed down.
If the internet tells you you're wrong, would you disagree? Got a spam call. It's too soon.
Have you reviewed it, Mr. Firehelm?
I see it.
And in this case, so you did actually impeach Deputy Himaseth on UTC time specifically, right?
I thought I had.
And so the record would speak on that point. Would you agree?
Yes.
Did you author your affidavit that was referenced earlier?
Yes.
In the time, it was not authored with the benefit of having your file, right?
That's correct.
Nor when your deposition occurred did you have the benefit of your file. True?
That's correct.
Because you had given it to ensure that the successor attorneys representing Mr. Mullis could continue their representation in the underlying criminal case and on appeal, right?
That is correct.
Knowing now, with the benefit of the records and the transcripts before you, is your testimony today true and accurate to the best of your knowledge?
Yes.
I don't have anything further, Your Honor.
Anything further, Ms. Nichols-Cook?
Just, Mr. Firehelm, do you know if you've ever seen the cell phone extraction data from Tristan Mullis's phone?
I don't think so, no.
And then just for purposes of the record, do we need to identify if there's someone in the room with Mr. Firehelm or not?
We do now.
Mr. Firehelm, is there anyone in the room with you? I guess I'm not sure if you're in your office or elsewhere.
I got the door locked and I've been here by myself all afternoon.
Thank you. I guess back to you, Mr. Duden. There was another question from your side. So. You're done?
Yes.
Okay. All right, Mr. Firehelm, it sounds like that should conclude your testimony. Thank you. I'll go ahead and end the Zoom at this time.
Thank you.
I think we need to make some merch that says, the internet says you are wrong. Oh, I like that one.
Okay, it is just about exactly 4:30, so it looks like this will be our ending point for the day.
What's the schedule going
we'll
forward?
We'll plan on picking back up at 9 a.m. on Monday. Council, if you'd like to stop back in chambers, obviously we can touch base about the schedule. Anything else we need to do on the record before we break for the weekend? Anything on behalf of the applicant? No? Anything on behalf of the state?
No, Your Honor.
All right, thank you. Have a nice weekend. I'll see you on Monday.
All right. Good stuff. Good stuff all around. I was going to read some more emails, but I don't know if we want to. There were some good notes in there somewhere. Where was the handwritten one? Okay, here we go. Page 1. This is from, it's addressed to Lynn.
Call from
Mr. Wisconsin.
Ivan, my friend, how are you doing today?
Hey, how's it going, everybody?
It's been an interesting day. This has been a spicy and also boring in some ways trial. But it's new and different.
It's kind of all jokes aside with that last witness. I do feel for him in a sense because he's up there trying to defend his losing performance, right? So it's sort of like you can go line by line, Monday morning quarterbacking every play, every decision. Why'd you say this? Why'd you say that? It starts to become a bit tedious at moments, I think. But I just have a theory on the whole scenario that the family found themselves in. I think Amy the more I hear about her behavior and rumors and alleged, and I think she was trying to embarrass Todd. I don't think she was trying to be discreet in her behavior. I really don't, because I think that she wanted out, and I think everybody sort of knew that, but he didn't want to give up what was his or thought was his, and so I feel like she sort of took the position, well, I'm going to make it like so miserable for you that I'm going to get it with every Tom, Dick, and Harry in town to where you can't even show your face. Even going so far as
the week before, they were saying, I love you too, and text message back and forth to each other. So,
well, fair enough, but I mean, just getting it on with the hired help and the police. I mean, you've lived in small towns already. This isn't behavior that's going to be swept under the rug.
Yeah, everyone will be talking about that.
Yeah, and I feel for the kids, because now dad's in prison. Mom's extramarital behaviors all over town, and so I just don't understand what she thought the end game was here. Like, did she really just believe? Like, if she wasn't trying to purposely, embarrass him, did she really, like, how narcissistic, or how, like, you really thought you were going to get away with it?
Let me back up. Let me back up a little bit. We've heard through testimony there were three relationships outside of their marriage. She was involved in three relationships outside of her marriage. One at work at the hospital, one was a deputy, and one was the farmhand.
Right.
In hindsight, it's possible that the hospital and the deputy were the same one, but she's apparently met them at the hospital. So it doesn't seem likely. Everything else that's alleged are just rumors, and small towns are great at starting rumors that aren't true as well. So we can't.
Well, and it doesn't help when it's easy to start rumors when the basis of the original rumor is true. Once you've had one affair, it becomes easy to name anybody, right? I would imagine.
But I don't know. I have a hard time looking at this and saying it's an accident, just because. I mean, how many times can you fall on a sword accidentally? It seems.
Did they do a toxicology?
Unlikely.
Did they do a tox screen? I don't know if I missed that.
I know she was on some pain meds or something, because she just had a procedure.
Like any good ones, or just regular?
Define good. Probably nothing you could sell on the street for good money, but Lortab, Percocet, Demerol. I don't know what it was. But she was on some medications because she had just had a procedure. She was dizzy. There's sides that there is enough there that, for me, I say at least that should be presented to the jury. I think if this goes back to the jury and if there's another trial, if the judge does grant this, and I think it was very telling that the judge said, "Did you ever look at this call log, this report?" He's like, "No, I didn't." That's a huge thing in the favor of Todd right now. But I think if it goes back, they still would convict him. I don't think judges generally would like to overrule other judges, and so I feel like it's a hard road to toe to begin with. When you get this is his last breath. So like this is probably like a 1 in 1,000 as it stands, and I just feel like by her granting a new trial, like, to me, that's sort of like a slap in the face to the original judge, in a way. But it's not the judge so much as his prior attorney. That's the one who's really going to be raked over the coals and say, "Yeah, you screwed up because of what you did. We have to do this all again," and drag everybody.
Does this guy still practice?
I think he has his license still. I don't know if he's practicing.
You might want to just.
He says office. I'm in my office by myself, so I think he probably does.
I'm in the office with the door locked, trying to keep all my old clients away after they see this. But I just caught wind. It's the anniversary. You and the Mrs. anniversary. Is that what I'm hearing?
Not yet. We've got a couple months for that one, but this spring, yes.
Oh, okay. Am I invited to the dinner?
It's probably going to be a Red Lobster. Just kidding. we have not. I don't plan this weekend out yet. I mean, I know what I'm going to do tomorrow as far as the bathroom remodel, but beyond that, those are future plans. I haven't got that far.
You're still doing this bathroom? I feel like I've been remodeling this bathroom the entire time.
I've watched every home repair YouTube video on YouTube, and all of them disagree, and none of them show me what I need to know. So I'm in there. It's like I'm all thumbs. I've got tools that I don't know how to use. I'm trying to.
Rumor has it bathrooms were redone long before YouTube was around. That's just a rumor, though. I don't know. Like, I've heard.
There's no proof. Show me the video. Show me the video. I'm still trying to get Mrs. RA to buy me a tool, though. I need an auto laser level that will do like a plus. So like no matter if you set it on a surface that's crooked, it automatically levels and will give you a horizontal and vertical line. You can like project it anywhere in the room, so you can always get something square.
Of course, RA is demanding some kind of nerdy tech tool before he actually starts his remodeling. Only you would require a piece of technology to start demolition.
Well, I have zero training in the area, and if there's a tool out there that will make it possible and or more practical to do it, I'm all in. So,
10-4. All right. Well, I hope everybody has a good weekend. Hope Selena's listening. Hope she recovers fast. She's one of my favorite anti-Aydens because we rarely agree, but I do love the back and forth, and so hopefully, if she's hearing this, she's not letting those firemen and EMS workers get by with anything. So
well, she did post in the Facebook group, so she's got her selfie, so you can see she banged up her head a little bit, and she's got an injury on her hand, and she posted a picture of the firefighters as well. So we've never had so many applications to join the Facebook page as we have. As soon as I said she posted pictures of the firefighters, and now boom, it's exploded. So make sure you answer the questions on the application, otherwise you get rejected and you have to do it again. So anyway, it's all good. Are you going to read the letter? I was going to read the letter that he wrote, the handwritten one. At least I'm going to try. So.
All right, good deal. All right, love you guys. Have a good weekend, and I guess how much longer do we have on this?
I thought it was going to be done today, and we're not.
Oh.
So we've got to look at our next case that we were going to pick up that starts. I think jury selection is next week, so I've got to look at that. I'm not ready to announce anything, so don't ask. I won't tell.
Does the state get you to call witnesses in this case, or is it strictly just Todd?
Oh yeah.
Oh,
both sides do.
Okay.
So.
Okay.
I don't know. Right. I don't know who they would call. Their rebuttal, their cross examination has pretty much gotten them everything they need. They can just rest. So.
Okay. Yeah, I don't know. I would seem to be a little redundant for them to. I think they're sort of reveling in the idea that they're on the other side of the table. There's like a persnickety sort of, vibe I'm getting from them. They don't often get to be on that, defense sort of mojo, and I think they're sort of enjoying. Playing that role. It's sort of like they're LARPing, for one case. And, but, all right, I'm out. Love you guys.
Awesome. Love you, man. See ya. Bye. There goes our Ivan Victor. Okay, so I'm going to read just briefly from this letter, and I've got it over here on this screen, so I'm sorry you can't see it. It's really hard to see. So let me see if I can read this. Oh, where can I need a bigger picture. Close that down. I think that'll work. Do I have a better zoom? Let's do 200%. Okay, I can zoom in. There we go. Okay. Picture says this. Where's my slider? It says, Lynn, by the way, her first affair was summer 2013. George, now something. Depositions are over. I thought they went well, except for Travis Hemseth. Boy, what a... I think he meant deckhand. But a lot of the letters are the same, but it doesn't spell deckhand. I think he says, what a deckhand. He is such a liar. He was saying the iPad was only mine and I was the only one that used it, and all this garbage. What crap. Everyone knew my password. Everyone used it. I had people stop and use it. How can I have been the only one on it when kids used it to look stuff up for hunter safety and several other things? We would sit on the couch and share the dang thing. He's waxing eloquent. For Pete's sake, pass it around at night. Lots of times, lots of times would have someone sit down beside me. Amy looked up her email lots of times for feed orders and such. She knew exactly how to use it. Taylor and Tristan too. He repeatedly said I was the sole user and crap. I won't deny I used it most of the time, but to say I was the sole user is Bolshevik. I think he says Bolshevik right there. Amy's email would come on it, and if you hit Gmail in search, you would have a choice of mine or hers. So how could it be just me that used it? I am not the sole user. I was the majority user, not sole user. Boy, he made me so mad I could foam at the mouth. It was obvious he was lying about his lack of knowledge about her first affair. Something around terribly. When as bad about his knowledge of it. His handwriting is so sloppy. Something Olive, I can't say what the name is, didn't know a thing either. Boy, how something is that. Deviant? Something. Nobody know nothing of that, but they say I just had to know of Amy's affair. They not like they something dumb, and I was so knowledgeable. If the whole hospital knew, the cops knew too. They are all intertwined. They can lie their butts off. Nothing happens. Then they just say, they twist whatever I say. 50 ways to get the easiest guy. Angie Barr lied her butt off in certain things. Her and Amy hardly talked after early summer 2018. Amy specifically texted me, but she couldn't trust Angie. Man. When Wyatt broke his arm, of course, I didn't like it. She never told me she was doing it. The only thing I was upset about. I never cussed out anyone. And besides, I had to stay at home with the other two kids. All this drives me crazy. A key point in Deb's deposition, I thought, was that, and then it goes off screen. Let's see. This is really hard to read. It's terrible handwriting in a blurry picture. Okay. One more time. Go back. I think I found the point where I can read further. Okay. So obviously he was lying about the whole first affair. It's so blurry. Just a single screenshot is just... As I'm trying to read this, and it's just terrible. Okay, that's as far as I can get. It's just, I tried to read it for you guys, but it's rough. With the letter through AI, I should probably do that. There are a lot of misspellings. Yes, and just there's highlighting, and looks like somebody went notes over it, and it looks like it was written by somebody who's left-handed in pencil. So you write with it's a mechanical pencil, and then your hand just smears the writing. It's terrible. It's just all blurred and everything else. All right, where are we at? Quick recap. We are concluding today with we finally got the last of the testimony from Todd Mullis's lawyer in his original trial, where he was convicted of murder. He was sentenced to life in prison. He appealed the sentence and he lost. And since he lost his appeal, that was like the last appeal he could make. In Iowa, there's the opportunity to sue the state for convicting you. It's called a post-conviction restitution or something. I forget. It's relief, post-conviction relief. And so he's suing the state, saying they did it wrong. And one of the things he's allowed to sue over is the fact that he had ineffective counsel. So that's what they're doing. Everything they raise in this hearing is to show that the lawyer should have done a better job. I don't know who else they would call after the lawyer's been on the stand, because everything leading up to that was to show him what he should have brought in, or to show the court what should have come in had the lawyer done the work. Now the lawyer's come in and said, I didn't do all those things. Now we're done with the lawyer. Who do you call next to prove this? Unless you call Todd himself. And that might happen. So we'll see. Maybe Todd needs to take the stand. That could be a really, really interesting day on Monday, and incredibly spicy cross as well, because that would be that would be next level. So lots of fun happenings today. Really intriguing. This is a process we don't normally get to see play out. That's why I'm so interested in it. It's sort of unique. We've never seen a PCR like this. And we'll see what happens. The judge will probably make a ruling, not from the bench, but at a later point. So at the end of this, we won't know how it ends up for a period of time. The judge has all the evidence to review, and she said she's going to read everything and then make her decision when it's all done. So that's where we're going to leave it. Mrs. R.A. has dinner on the table, so I've got to go. Let me tell you, though, in 1 week from tomorrow at 8 p.m., Valhalla Awaits has invited me on to be a guest at a Lego build stream, meaning I have a Lego set that is coming to me right now. I'm not going to tell you what it is. It's going to be a surprise. And I will be sitting at this desk. I'll clear some stuff off, some of the tech off. We'll have cool camera setups, and you're going to watch me be interviewed by them, and they are going to build Legos at the same time. So it's a very laid-back stream, and we're all focused on our Legos and just having a fun conversation. It's a lot like a podcast as far as kickback. It's funny, it's unscripted, it's live, and you're invited. So do plan to be there, and also you might want to click the subscribe button on Valhalla Awaits channel. It's going to be awesome. So I've watched. We've got great people that have been on there. I know. Rob has been on there. I watched his. Brandy Churchwell's been on there at least twice. How did she get on twice? I haven't been on yet. She's doing great. She's doing amazing. She did really well. I watched hers as well. So good stuff. Tonight when you go home, please hug the people you love. Smile at someone. Make their day just a little bit better. And please stay safe till we go live again. It will be Monday, barring some unforeseen circumstance that will require us to go live and cover some weird news story somewhere in the United States. Why is that? Why is that broken? Oh, it's not broken. I thought it was broken, but it's not. Squirrel! Sorry. Congrats on 64K. Thank you. 64.5. That's awesome. Selena, you're in our prayers. You guys have a good weekend. We'll see you on Monday.
Thank you, sir. You're my new best friend.